Miss Javier, you fix a time and bring him, inform him a particular time and bring him. 2:30. What is this? One o'clock. 1 o'clock is okay. All right, 1 o'clock.
Adjournments page wise, page number 11, cylinder 42. Page number 12, cylinder 43 to 53. Page number 30, cylinder 54 to 60. Page number 14, cylinder 61 to 66.
Sure. Who's appearing for the petitioners? You are the petitioner. Who's the respondent? Learned counsel for the petitioner seeks time on the ground that the matter is in the process for amicable settlement. Relist this matter after a week is okay. Relist after 2 weeks. Next. All right, 2 weeks run.
Page number 67 to 71.
My last serial number 60.
Page 16. 20.
Serial number 68, my lord. 67, my lord.
Yes.
Page time, my lord. Inconvenient matter, my senior counsel matter.
60?
67, my lord.
What do you want?
I am the petitioner in my lord. Informed.
You are for appeal for what?
Appear for petitioner, my lord.
$67 at the request of counsel for petitioner relist next week. Next.
Page 16.
Serial number 68, my lord. Serial number 68, my lord. Serial number 68, my lord.
Anybody for the respondent?
68, my lord.
Malappa.
Appearing for the
Request of
petitioner.
learned counsel for the relist.
Serial number 68, my lord.
60?
Appearing for the petitioner. 68. 68, my lord. Page number 68. Page number 68,
Yes, what do you
my
want
lord,
in
appearing for the
what do you want in
prays for a
68?
short accommodation. Short accommodation, my lord. As senior is out of town to attend his mother's
next.
ceremony.
Page number
Prays for a
16.
short accommodation. 68.
68 at request of released week after next. Next.
Page, I just said adjournment.
Oh, no.
Page number 16, syllabus 72 to 78.
Much obliged, my lord.
Sorry. 76, huh? What have you, sorry?
You of not proposing correct, written statement.
Stuff up, that's what you are challenged. Can you word your memo of withdrawal? Who has given this dictation? You have given. Oh, the other, artha agutta. No, in this only you make corrections. Learned counsel for the petitioner present before the court. He seeks withdrawal of the petitions for the reasons stated in the memo. On the submissions, petition is dismissed as withdrawn. You want withdrawal, right?
Page number 17,
Lordship,
serial
serial
number 79 to 84.
Lordship, serial number 77, Your Lordship. I am appealing for the petitioner. Lordship,
Petitioner.
serial number 77, Your Lordship.
Request of learned counsel for the petitioner. Relisted after 2 weeks.
Lordship, serial number
Learned counsel for the petitioner seeks time, same is granted, relist week after next. Yes,
Your Lordship, serial number 77, Your Lordship, appealing for the petitioner. Your Lordship,
Next.
maybe granted 16, maybe.
Page number 80, serial number 85 to 90.
filed. The counsel for the respondent number 2 seeks time, same is granted, relist after 2 weeks. Huh? You're for? The counsel for the petitioner seeks time, relist after 2 weeks. 85 next week ಅಂತ ಮಾಡಿ. Interim order stands extended, if any, till next date of hearing in 88. Request of counsel for petitioner relist after 2 weeks. Yes,
Your
counsel who is online,
Yes,
video
Your
conferencing.
Lordship, serial number 77. Appealing
What
for
is
the
that computer, man?
appealing for the petition. Your Lordship. Serial number 77, Your Lordship.
ಅವ್ರದ್ದು ಫ್ರೀಸ್ ಆಗಿದೆ.
Your Lordship, serial number 77.
Mr. Counsel, I am unable to hear you. You are also further disturbing the code. You can send somebody or mention at one time.
Omelette, Your Lordship.
Fresh matter. Final, serial number 1.
You can use the mic is provided for you. What secured? You secured the seat.
Reporting joining report to the final. Final has not been uploaded. Recording of the so that
This is the government quota. Or who appears for K? Where is K? Ramesh? Where is he? He has to answer. No, that first step is KE. KE has to put it in the portal. Only then the college will come into play. If KE doesn't put it in the portal, that is your case, right?
The college is not uploaded.
Who has to upload? College has to get information from whom? Who has to do the first act? Approve it. Is it not the system of counseling that when you select a college in the computer online counseling, the KEA comes into play and then they will upload it and then the college uploads it thereafter? You reported to college. You paid the fees. Okay. So the seats, how many seats are available now? Available on the government quota? That is the government quota. But you are coming under government quota. So one seat is available. Yes. What do you say, madam? Answer. College and PE has to answer. Work called heard. Heard learned counsel for the petitioner issue. Major notice to respondents 2 and 2 to 4. Learned AGA represents the respondent number 1 state. Learned counsel for the petitioner is also permitted to take out notice by way of hand summons to the panel counsel appearing for respondent number 2 KEA. What about medical counseling committee? CGC. CGC appears, ESG, deputy ESG. Learned Deputy Solicitor General of India is directed to accept notice on behalf of respondent number 4 registry to show the respective names in the first list. In the meanwhile, Mr. Shanti Bhushan, you will take notice for R4. Medical Counseling Committee, Nirman Bhavan, Delhi. Yes. So the registry to show the name of learned Deputy Solicitor General of India for R4. Yes, we'll grant an interim order. What's the difficulty? All right. Meanwhile, now you are attending class already. This is what? Medical course. Then there's a separate roster. No, that is for fee fixation or even admission. No, you find out. No, I think it is fee fixation.
Admission is concerned, my lord. Division means, my lord.
Seat allotment, fee fixation are all. Yes.
My lord, there is a division bench is admission seat is concerned. My lord, is division bench.
All right, you go tomorrow itself. Because if I have no jurisdiction to pass any order, may not be appropriate. It is submitted by learned AG and learned Deputy Solicitor General of India that the prayer sought for in this writ petition warrants the matter to be placed before the Honorable Division Bench of this court having roster to decide the matter. Accordingly, registry to place this matter for the Honorable the Chief Justice of India, Karnataka, to place this matter before the roster. You can move the bench. You can move the bench today afternoon or tomorrow. You serve a copy so that they are also in advance notice. 4 weeks time granted to rectify the objections. 3 weeks time granted. Next.
My lord, serial number 2.
2 weeks time granted if needful done, issue notice to respondent. Same order.
Copy has not served, my
4
lord.
weeks time granted. If needful done, issue notice to 2 and 3.
Marius,
Yes,
Serial number 8, Mala.
ಮಾಡಿಲ್ಲ. Stay ಇದೆಯಾ? Can you just call that computer person, whether it fault on our side or where is it? So who's appearing in serial number 8?
Please, my lord, I am for the petitioner, my lord.
Anil
2 days
Kumar.
time, my lord. 2 days time, my lord. I'll comply the office
No
objections, my lord.
representation on behalf of petitioner.
My lord, I am appearing for the petitioner, my lord. My lord, I am appearing for the petitioner, my lord. Kindly 2 days, my lord.
All right, at request of counsel for petitioner, released next week.
My lord, serial number 6, my lord.
Anil Kumar, you are able to hear the court.
I am able to hear, my lord. I am able to hear, my lord. But there is some disturbance, my lord.
But you are not audible. I don't know whether the fault is from our side or from your side.
My lord, I am hearing you. I can hear your lordship's voice, my lord.
Okay, week's time granted. 1 week time granted, sir. Next.
My lord, serial number 6, my lord.
You call, you don't touch that. Barakili.
My lord, serial number 6, my lord. Sorry, my lord, straight. Serial number 6.
A. Harish,
My lord, serial number 6, stay may be extended, my lord. Serial number 6.
Serial number 6 ಏನ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು? Weeks, 2 weeks, Mr. Venkatesh.
Yes, sir. Stay may be kindly extended, my lord.
Stay, if any, stands extended till next date of hearing.
Much obliged, my lord.
Harish. Weeks time granted. Good. Needful done, issue notice to respondent number 4.
number 10.
I represent the petitioner, my lord. The summons have been served on the LRs of the deceased first respondent, my lord. They have one claim. They have one claim. Then the service may kindly be taken as served and
Postal shara of notice issue R1 in brackets A to D. It's written as unclaimed. Said notice is very sufficient for the name of R1 A to D, the cost list. Interim order stands extended till next date of hearing.
11.
For what? Who has died? Huh? No, who the petitioner, respondent, who has died? Have you brought the LRs? Have you brought the LRs of petitioner? Non-amendment of cost title and TGL cost list. Huh? Why next week you do it now? Why? Why I should give you 1 week? Take it now and carry out the amendment. 2016 year. Who is dead now? Respondent. R1. Venkat Reddy appears. Now when that R1 died? Leonard, has it been reported? When? Now only a report. Learned counsel for the petitioner reports of R1. Between the legal representatives on record, same is granted. 2 weeks time granted to file necessary steps. Counsel for the petitioner to carry out the amendment during the course of day.
My lord, serial number 12 appearing for the
Balakrishna
petitioner, my
Shastri.
lord. This writ petition has become infructuous, my lords. The suit in the trial court has been dismissed, hence the writ petition has become infructuous, my lords. For the petitioner, my lords.
Have you filed a memo? You want to withdraw or you want dismissal as becoming infructuous? What do you want?
Dismissed as infructuous, my lords. Memo has not been filed, my lords.
Learned counsel for the petitioner present through video conferencing submits that the petition has become infructuous. The submission is placed on record. The petition is dismissed as having become infructuous.
Please. Great.
Right. Learned counsel for the petitioner submits that he will comply with the objections raised to the registry. 2 weeks time granted. Yes, you are from the department. Unable to hear whether it is from this side or that side. Unable to hear under there is a less of because of the bandwidth of theirs, or I don't know whether the net is working fully. Where some everywhere. To rectify it, or what for you here for them? When you will rectify after a half day, unable to hear any of them properly. What if somebody wants some urgent interim order? You cannot say that everybody today somebody is having. Balakrishna Shastri.
My lords.
Let's call out. You wait for some time. Call out next month. They want to stand extended is extended for period of hearing. Uma Shankar. When did that respondent die? Petitioner. When did he die? Huh? Sorry. You are appearing for petitioner. You don't know when your petitioner has died. Hmm? Okay. Learned counsel for the petitioner seeks time to take necessary steps as he has no instructions with regard to the legal representatives of deceased petitioner. 2 weeks time granted. Next. Why this notice of petitioner was sent? KV Narasimhan. He's come back as absent. The postal shara of notice sent to the party in person petitioner is returned as party absent and intimation served. Hence, in order to provide one more opportunity to the petitioner, release this matter after 2 weeks. Srimati Radha. Sorry, retirement. Wakalat is there. But petitioner has filed a memo dated 12/7/2021 seeking retirement on this case. Memo of retirement reads as and stop. Memo is also signed by the petitioner. Accordingly, petitioner is permitted to retire from the case. Issue registry to issue court notice to the petitioner. Vivekananda Venkata Venkana Gowda. Venkana Gowda. Venkana Gowda. No representation on either side. 13%. Why that is not shown here? Party in person Only Shri Venkana Gowda D is absent. However, he has filed a memo seeking withdrawal of this petition. Memo reads as under. It is submitted that the writ petition has become infractuous and sought for dismissal of this writ petition on this grounds urged in the memo. Accordingly, writ petition is dismissed as having become infractuous.
Number 18.
Ananda.
Ananda.
2 weeks time granted at request of petitioner.
19.
Lakshmaya.
Yeah.
Lakshmaya. You're unmuted, sir. Unmute your system.
Yes, my lord. I am for the petition, my lord, that number 4 of respondent is no more in the service. I wanted to file an IA to delete and strike out his. Kindly, I am filing an IA to delete the name of respondent number 4, my lord.
Why?
Because he is no more in service, he is retired, superannuated, and in his place, serial number 5 is also taken the charge. Therefore, I may kindly be allowed to file an IA. I am filing in 1 or 2 days. And file a memo, my lord. IA.
All right.
Please.
A week's time is granted
Much
to
obliged.
the petitioner. File necessary application as sought for today.
Much obliged.
What is the memo you have filed? Why are you counter? Let her submit. They're not standing in some panchayat where you can continuously together. What is your memo of 6-1? Furnish copy of examination history. Result processed. Result pass. What is the prayer? Answer script of the petitioner to third evaluator of evaluation as per directions issued by this court. Announce the results. Average of best. For which year? Is what is your prayer? That has been conducted. She has produced, now it says that you have passed.
Yes,
Which regular exam? You have taken one more exam after that revaluation. No interim order. And what survives in this case? ಅದನ್ನೇ ಅವ್ರು ಆವಾಗಿಂದ ಹೇಳ್ತಾ ಇರೋದ್ರಿ, wasting time of the court. We should also say nothing survives. Anything survives in this petition? Learned counsel for the, you're on record. What's your name? Learned counsel Pradeep Patil is present before the court. He submits that the petitioner has already passed the first year. What examination is? First year MBBS examination. And therefore the prayer sought for in this writ petition would not survive for consideration anymore, which is also the statement of learned counsel appearing for respondent. You are not filed wakalat. Accordingly, this writ petition is dismissed as having become infructuous. Learned counsel for the, you are appearing for. All right. Learned counsel for respondent is given 2 weeks time to file wakalat. Should say so fairly before the court, petition does not survive. No, adu idu anta you are wasting the time. ನ್ಯಾಯಕ್ಕೆ ದಾವಾ ಹಾಕಿ ಅದು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. Next. Has it been served? Has it been served to your client for retirement? Good. Where is the acknowledgement? Learned counsel for the petitioner submits that she has filed a memo seeking retirement, but however, the copy of notice of retirement is not served on the petitioner, and neither any acknowledgement is placed before the court, hence rejected. Next. Then counsel for the petitioner seeks time, 2 weeks time. For what? Argue the matter. What is this non-filing of application by advocate for petition? Which application? For what? That is not your prayer in the writ. You serve the copy first. To whom? You filed it today. That counsel submits that he has served the copy of the application today. Release this matter on 13th. Learned counsel for the petitioner seeks time. Release this matter next week. Unclaimed. Unclaimed ಸರ್ವಾಗಿದೆ. For R3, 2 weeks. 2 weeks. 2 weeks granted at request of counsel for petitioner to take steps for R3. Interim order stands is extended till next date of entry. Here. Provide service of notice R5 to R7. Two or three? Which respondent? Only respondent. Sole respondent.
The receiver's name is also the respondent.
Notices come back as no such person.
But the receiver's name itself is the respondent.
What is this case? Hmm. There is a petition pending. Who was filed there?
The respondent.
You have taken notice there. Already you served the copy of the to the counsel appearing in the family court at Bengaluru. Learned counsel for the petitioner is permitted to take out notice of this petition to the counsel appearing for the respondent before the family court at Bengaluru. You have taken notice in the family court. You are the respondent wife. Have you appeared in the family court? Have you filed wakalat? Have you appeared in the family court? Present ideyalama. Take out notice. You serve it and bring it next. We'll release this matter next week after next. Now it's only initial stage of mediation is ordered. Nothing adverse is going to happen. You need not come. If mediation is over, once then you file statement. Yes. Put it memo for withdrawal. Not signed. ML Gowda. Memo for withdrawal of the writ petition is referred by the petitioner's counsel without the signature of the petitioner himself. So release this matter next week. So the order. ಏನ್ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಿಮಗೆ? ಆರ್ಡರ್ ಶೀಟ್. ಶ್ರೀನಿವಾಸ್ ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ವಾ? ನೀವಲ್ಲಿ ಪಾರ್ಟಿ ಇದ್ರ? ಎಲ್ಲಿ ಯಾರ ಮುಂದೆ? ದೇವ್ನಲ್ಲಿ ಏನ್ ತಹಸೀಲ್ದಾರ್ ಕೋರ್ಟ್ ಎಸಿ ಕೋರ್ಟ್ ಯಾವ ಕೋರ್ಟ್? ಸಿವಿಲ್ ಕೋರ್ಟ್. ಕಾಪಿ ಆರ್ಡರ್ ನೀವು ತಗೊಂಡಿಲ್ಲ? There is no representation on behalf of petitioner. Party in person Srimati Venkatamma. Respondent number 5. Respondent number 5 is present before the court physically. She seeks time. Yavag bekama? Just give her a date on it. 25 ಬರ್ತೀರಾ? Relist on 25th.
Number 29.
Yes. What are the objections on that? You mentioned Hindu newspaper. Where is the, for whom? Respondent number 2 is located where? Respondent number 2 is located where? Huh? Respondent 2 is already on record. So you're taking newspaper publication for? Okay, you written R2. Counsel to rectify the objections raised by the registry. Relist after 2 weeks. First you rectify, Mr. Counsel, you don't even know for whom you want to take notice. What does your application say? I'm not sitting here to scrutinize your paper, whether you have written R2 correctly or not. It's your job. Please go and do it correctly. Why was it dismissed? The court. These two applications, IA1 of 22 and IA2 of 22, are filed to condone the delay of 82 days in filing the application to recall the order dated 6/6/2022, wherein this court passed an order of dismissal of the petition for non-appearance of the petitioner. Full stop. I perused the affidavit annexed to these two applications. The reasons assigned and the cause shown therein appear to be satisfactory and genuine and bona fide. Same is acceptable. I do not find any legal impediment to disallow the legal impediment to allow the petition, the application. Accordingly, IAs 1 and 2 are allowed. Delay of 82 days in filing the application to recall the order is condoned. Accordingly, the order dated 6/6/22 is recalled and the file is restored. Petition is restored to its original file. What is this matter? The challenging what? Released after 2 weeks. So if it is ready, you have to serve copy to them. And what is the point of Passover? They have to also read what you are going to say in the rejoinder. You are the school, college. What are you? School. High tension wire. So you stop them from. So now you have an interim order. Do you have an interim order? All right, you continue. You serve copy on them. Learned counsel seeks to what application you are filing? Objection. Learned counsel submits that you would file the statement of objection within a day. The same shall be served to the learned AG and respondent number 6. Relist next week, madam. Next week. Yes. Interim order is extended till next date of hearing. What is your prayer in the writ? Huh? When is the order passed on 2020? So what is your case? It's a grant. What is the order? Implement order. Put who in possession? Put who in possession? Sir, what is the interim order? You are unable to hear me. If you now ask for vacating, what happens to the main petition? You're the original grantee. There is an order by the deputy commissioner to put you back in possession, which he has challenged. Now you are asking for vacating. How if I vacate, what survives in this petition? The application for vacating stay shall be heard along with the main matter released after 3 weeks. Next.
Yes.
Yes. OPS. Who has to announce the result? Now you are continuing in the course? In this, which year? Second year? Correct. You are awaiting the result. Correct, sir. Now you are continuing. You are continuing. You continue, let him take instructions. You want the result to be announced. In case you pass, you continue. If you fail, you have another option of one more exam, right? When you will take instructions. All right, release this matter on 16th, 17th? On 17th, at request of counsel for respondents 1 and 2. 33, 34 to be tagged with one more. That is pending. Registry to list WP number so and so along with these 2 petitions. Write down in a chit and give it. Yes, these 2 are same along with the 3rd matter. Yes. Yes, Mr. Senior. Evidence of was closed. Sir, your friend is submitting. You're the plaintiff. Who are you?
They are all saying they are asking for partition. Asking for partition. But my evidence was recorded.
You're appearing for which defendant, Mr. And senior counsel? 7th. So you're not a family member, you're purchaser.
The main fact, operation the impute order shall be stay. God. Because they person can teach you to God. They are ready to there is a direction. It should continue without interruption in any manner. That is
What are you reading? Have you given a copy to him? Sir. No, who has filed this? SL? All right, read the.
Questioning the presence of advocate for different members in the video conference and that was the reputation was dismissed. And it was taken up as a himself before the Honorable Supreme Court. The Honorable Supreme Court, what it said is, it dismissed the SLP that was private. Dismissed the SLP private. And it also directed that the private was on and 1 week was again was rejected. First challenge before they wanted to was rejected. First challenge before and meditation came to be allowed. Again, the subject matter is strong. There's a lot of intention for if one is for the trial court, our advocate for different the order passed with the order stating that no, even evidence of legal was
You filed criminal contempt, stopping. But when is the suit listed? See, all of you are senior members. If you simultaneously speak, it's not right on your part. You should allow the other person to speak and you will be given an opportunity. Without hearing you, this court is not going to pass an order. Please understand, you're senior members of the bar. Now, what is the stage of the suit, sir? What is the stage? When is it listed, sir?
27 defendants, 70 defendants has to lead the evidence, 90 defendants have to lead the evidence, they are all family members. It should have a reasonable opportunity to lead the evidence. The Supreme Court says, where when gone does not get our rights.
Yes.
Say that there are 27 defendants. So what does the senior member of the court?
All right, the fact remains that they have not been given evidence. Now they are challenging the order of not permitting them to lead evidence. Where is the order of the Supreme Court that they should not lead evidence? Show that. It has to be considered.
Both ones they have not proceeded the matter. Meantime, they have not come forward to give you evidence.
All right, you want to place certain records? Barcode. Bernard, counsel, you are appearing for whom? Is your name? You are filing wakalat for R1? In 511? R2. You are plaintiff, Allah. R2. What about you, Mr. Counsel?
But in 511, I appear for R1. There will be 512.
But learned counsel, all right, learned senior counsel, Mr. Reddy, Allah. What Reddy? Sada, learned senior counsel Sri Sadav Reddy on behalf of J.M. Rajana Shetty appears for the petitioner. Learned counsel Sri Madhusudan Rao. M.N. Madhusudan Rao. A. Madhusudan Rao accepts notice on behalf of respondent number 2. Learned counsel Sri Rajeshwar P.N. and P. Ram Prasad accepts notice on behalf of respondent number 1. Registry to show their respective names in the cause list. Full stop. Counsel for respondents seek time till tomorrow to place certain material on record. Same is granted. What about in 512?
I made an application, process an order on 6th, closing that I am not permitted to file a return statement. First,
all right, I'll hear you on the. So here you are appearing for R1. Learned counsel Sri C.M. Nagbhushan is present before the court representing petitioner. Learned counsel Sri Madhusudan Rao accepts notice for R1 and learned counsel Sri P.N. Rajeshwara and Ram Prasad. Same, whatever name stated earlier. Appears for respondent number 2. Registry to show their names in the cost lists. In 514 also same?
Yes,
Same ordering. In 514 is R3 and you are R1. In 514 Madhusudan Rao for R1 P. N. Rajeshwar and Ram Prasad for R3. Release this matter tomorrow. Whatever stage it is, you can mention. No, you can mention it. Come in the same stage. It will come in the same stage. Issue notice to the other respondents. Learned counsel for the petitioners to take out notice of this petition to the respective councils, to the council representing the respondents before the trial court. If you do not precipitate, then yes.
One also, but examining. So I may have, I might have. We'll try to argue that application.
I don't mind granting you time, but you should not precipitate the matter day after tomorrow. No question of staying the entire proceedings. It is only the order that is going to be stayed. All right, perfectly. Release this matter on 12th. In the meanwhile, the plaintiff shall not precipitate the matter in arguing the main matter. The other proceedings of IA shall continue.
Number 38.
Aja. Use the mic. Mic is given for your purpose. You keep it behind your head. How can I hear? No representation on behalf of petitioner released next week. Counsel for respondent is present.
39.
You're ready? Stay is granted. You want the transfer from Harihar to Channagiri? What is the petition preferred by you? You don't want to settle and live with your wife? Whether that was contested?
there is no even convenience to hide. Suppose I have shown the application Shimoga. This is residing in Shimoga, notice for notice. Applicant notice number in Shimoga. There are no updates in your transfer this petition to Shimoga. But I will have to hide. Suppose that she is resident of property as that hearing court is sitting on command court. In a few days or in a week now. It is only a hardness for this one. So, reason is that I have no objection to this. So, okay, hearing court. Hearing court to go.
He is a resident of the Channagiri Taluk in the Ravangare and there. Where? Channagiri. So how far is that from this court? Shimoga, how far is Shimoga court? How far is the court at Shimoga? He says he is residing in Channagiri. Please understand, now he is before the court. He is the correct person to say where he is staying. You may have served notice on Shimoga in your petition. And the change madakagalva avaru. Mate? That is for him to say, yes. To go to? What is the distance from Harihara to Channagiri? What is the distance? You are not in Shimoga. How far is Shimoga from Channagiri? So Shimoga is ruled out. He is not in Shimoga. When, which year was that?
So, once in a week, 3 days sitting at Varnali. That Varnali one of the proceedings is not.
The regular sitting is in Channagiri. No, regular sitting. Correct. Now the matter is pending in Harihara. That's a regular sitting?
Regular sitting, 3 days once.
So in Harihara, there is no regular everyday sitting. So 3 days sitting at Honali. What about Channagiri? What is the distance from Honali to Channagiri? All right, you go to Channagiri. You go to, we'll transfer it to Channagiri. Barkoli. This petition is filed by the wife seeking transfer of the matrimonial proceedings in MC number 15 of 2020 filed before the senior civil judge and JMFC Harihara by the respondent husband, who has initiated a petition under section 13 of the Hindu Marriage Act for divorce. You have not filed any petition. Is there any child? the contention of learned counsel for the petitioner wife that she has no source of income and has how many children? 2 minor children, and it is very difficult for her to travel from Kattalagere village, Channagiri Taluk to Harihara, which is 65 kilometers. And if she travels to Harihara to attend the court case, then she would be incurring enormous amount of expenditure, including stay and accommodation. And as of now, no maintenance is awarded by the court. Therefore, there is inconvenience and hardship that would be caused to the petitioner if she has to travel to Harihara, leaving 2 minor children back home to attend the court proceedings. It's also seen that the respondent husband is a resident of Honnali Taluk. The distance from Channagiri to Harihara is more than 65 kilometers. And from Honnali to Channagiri, what is the distance? 47? 47 kilometers, as stated across the bar by the learned counsel for both parties. Accordingly, I do not find any impediment for the respondent husband to travel 47 kilometers to the court at Channagiri if the matter is transferred for adjudication before the senior civil judge and JMFC Channagiri, which would cause less amount of hardship and inconvenience to the petitioner wife and 2 minor children. To stop accordingly. Yes? Huh? It is also submitted by learned counsel for the respondent husband that the divorce petition referred by him is before the senior civil judge JMFC Harihar, but the court is sitting at Honnali in 3 days a week. And therefore, the petitioner residing at Kattalagere village, Channagiri Taluk, would be closer to Honnali. And therefore, there would be no impediment for her to travel from Kattalagere to Honnali. Hence, he seeks dismissal of this petition on these grounds. Stop. However, the petitioner is maintaining 2 minor children and she is residing at Channagiri. Kattalagere village at Channagiri Taluk. Therefore, the hardship and inconvenience would be caused more to the petitioner in traveling from Kattalagere village, Channagiri Taluk to Honnali Taluk. Where is that Harihara? To Harihar. Therefore, I feel it appropriate to transfer the matrimonial proceedings pending before the senior civil judge JMFC Harihara to the learned senior civil judge and JMFC Channagiri. First up, accordingly, I pass the following order. Petition is allowed. The proceedings in MC number 15 of 2020, pending on the file of senior civil judge JMFC Harihara, is ordered to be transferred to the file of senior civil judge and JMFC Channagiri to be adjudicated in accordance to law. Full stop. Party shall appear before the court at senior civil judge JMFC without awaiting for any further. The notice will be ordered, I think, afresh, or you will appear. Is transferred as yes. Javeed. Suresh. Yes.
Ravi, yes.
What is this? Transfer petition? Matrimonial proceeding. Matrimonial. The friend is not here. Your objection? What is pending? You are having objection for transfer. None appears for the petitioner. Learned counsel for the respondent to present relist after 2 weeks. Ravi Kumar. Yes, Mr. Hala Shetty, any objection? We'll transfer it. This petition is preferred by the wife seeking transfer of the matrimonial proceedings filed by the respondent husband in MC number 108 of 2020, filed for dissolution of marriage, pending on the file of First Additional Family Court at Tumkur. Full stop. It's the contention of counsel for the petitioner that the wife has preferred a petition bearing number 4277 of 2020 for restitution of conjugal rights. You have filed before the First Additional Family Court at Bangalore. Tumkur and Bangalore, what is the distance? 60. There are other proceedings also pending before the family court at Bangalore. That is 498A. So apart from this section 9, there is 498A and also DV Act. Idhara. Yavudu bittilla adare. 28 years and 34. Why you have not gone for mediation? Agta illa. Barcode. In bardri. Yes, she has also referred a registered a criminal case in crime number 137 of 2020 for the offences punishable under section 498A, capital A of IPC, read with section 3 and 4 of Dowry Prohibition Act, which is pending before the court CJM at Bangalore. Stop. Any children from the marriage? He further contends. It is a further contention of Lord Counsel for the petitioner that the petition preferred by the husband at Tumkuru is about 100 kilometers distance from Bangalore. And therefore, it would be difficult and hardship would be caused to her traveling from Bangalore to Tumkur. Therefore, she seeks for transfer of this petition filed by the husband at Tumkuru to the family court at Bangalore. As two petitions are pending, one the restitution of conjugal rights and the other case filed under the criminal procedure for the offences under the IPC. And also another case is filed under the provisions of section 12 DV Act, which is also pending in the JMFC court, third MMTC at Bangalore. Therefore, I do not find any legal impediment to transfer this matter pending before the court at Tumkur in MC number 108 of 2020, the court at Bangalore. for adjudication of the matter at Bangalore. Full stop. It is also apparently seen that less amount of hardship would be caused to the respondent husband in traveling to Bangalore to attend these 3 cases rather than the wife traveling from Bangalore to Tumkur to attend one case preferred seeking divorce by the respondent husband. Full stop. Accordingly, I pass the following order. The matrimonial proceedings in MC number 108 of 2020 pending on the file of First Additional Family Court at Tumkuru is ordered to be transferred to First Additional Principal Judge Family Court at Bengaluru, where the proceedings initiated by the petitioner wife in MC number 4277 of 2020 is pending, and both these matters shall be called together and taken up together for adjudication of the matter. When is the matter listed in Family Court at Bangalore? All right. No, you can appear here and they will give another date. It is also submitted by the learned counsels across the bar that the matrimonial proceedings in MC number 4277 of 2020 pending at Bangalore is listed on 13th of January. Both the parties along with the respective counsels shall appear before the Family Court at Bangalore, and the learned judge of the Family Court shall assign a date for appearance for continuation of the proceedings after the matter is transferred from the Family Court at Tumkuru to Bangalore without awaiting any further notice. Your objection is a transfer petition. Your objection. Huh? Annexures are not received. Seeking for transfer of the proceedings in MC at T. Narsipura to Chitradurga. You want from Tree to Chitradurga. What is the distance?
Number 3,
There's some objection raised. You are not cleared that. Type copy of manuscript of the order sheet of Skinner Miscellaneous 574. All right. What is the objection you have? All right. We'll have it next week. Office objection is immaterial now to consider transfer. Next week, at request of counsel for respondent released next week. Going to Bangalore. There is already a stay order. So Madhugiri court is a regular court, or is there a sitting in Kortagiri for some? And transfer to Kortagiri is wrong. So you have filed a CMIS and you have filed which is a EVL. Page? Hmm. Why? Who was residing in Madhuguri? No, as on date of filing of the petition by the husband, respondent, whether he was residing at Madhugiri, whether you are resident of Madhugiri, then why he has gone and filed in Madhugiri? You have filed under section 12 and both are pending in Bangalore. This petition is preferred by the wife seeking transfer of the matrimonial proceedings pending on the file of Principal Senior Civil Judge and JMFC Madhugiri to the Principal Judge Family Court at Bangalore for adjudication. It is submitted by learned counsel for the petitioner that she has preferred Let's find a crime case in number 202 of 2017 for the offences punishable under section 498A, 506, 504 IPC, on which a charge sheet has been laid against the respondent, husband, and others. Only respondent in CC number 18939 of 2017. And the same is pending before the 5th Additional Chief Metropolitan Magistrate at Bangalore. Correct? And where is the DV case pending? Full stop. The legal counsel further submits that he has filed criminal miscellaneous number 78 of 2017, seeking for maintenance. This is under DV Act, under the provisions of Domestic Violence Act, which is pending on the file of Honorable Metropolitan Magistrate, MMTC, Traffic Court at Bangalore. Full stop. It is his contention that the respondent is a resident of Bangalore and he is employed in Bangalore, and he has produced Annexure D, which shows that the respondent is working in Sansera Engineering Private Limited, which has its office located at Garbe Bavi Palya, Hosur Road, Bangalore. And this residential address is shown as Shanti Nagara, Shanti Nagara, Hungasandra, Bangalore. Therefore, it is apparent that respondent is a resident of Bangalore and working at Bangalore. It would not be difficult for the respondent to attend the proceedings in case this matter referred by him at the Senior Civil Judge JMFC Madhugiri is transferred to the Family Court at Bangalore. Full stop. All the more, for the petition to be transferred to Bangalore is 2 petitions preferred by the petitioner wife is pending in the courts at Bangalore. And since the respondent is a resident and working in Bangalore, it would not be inconvenient for the respondent to attend to the proceedings at Bangalore. Accordingly, I pass the following order. This petition is allowed the matrimonial proceedings in MC number 3 of 2020 pending on the file of Principal Senior Civil Judge and JMFC Madhugiri is ordered to be transferred to the Principal Family Court at Bangalore for adjudication. To stop. No order has to pass. Shakir Abbas.
For respondent.
One from Mandya to Bangalore. What is this? 22 years. Your client is aged 22 years. When was the marriage? Huh? All right. Where is your friend? Shakir Abbas. You have filed any petition? Huh? You have filed in Bangalore. It's pending. But there's a stay granted. Who has moved this matter? Who has moved the matter? You have moved the matter. For what? But already there is stay. Your friend is not here. Let him come. We'll have it next week. Learned counsel for the petitioner is present. There's no representation on behalf of the respondent. Relist this matter next week.
If I please, my lords, I appear for the respondent husband. The matter could be referred to mediation, my lords. Let the parties explore the possibility of settlement. That is my respectful submission. If my learned friend concurs.
Have you filed any petition? Have you filed any petition? You don't want to go and stay with your husband? Why? Your client is willing to join, or you want separation?
My lords, I have filed for divorce, my lord. If my instruction is that they also prefer for divorce. If terms have to be settled, my lords, if that could be worked out in the mediation center, that could be done. That is my respectful submission.
I have no instructions. Why pray for time? You go to mediation center. Appear before the meeting. Where are you a resident of?
Bangalore, my lords. Wife is in Bangalore. I'll travel to Bangalore. Let it be listed before the BMC.
Pending consideration of this petition, both the parties along with the respective counsels shall appear before the Bangalore Mediation Center. On when you will appear?
Their convenience, my lord. I'll travel to Bangalore. No problem.
You are resident of which place? You appear on 20th.
Very well.
You want to appear on 20th or 27th? On 27th.
Time may be fixed.
27th at 3 p.m.
Very well, man. I'm great.
7th at 3 p.m. to explore the possibility of settlement, if any. The party shall appear before the Bangalore Mediation Center without awaiting for any further notice in this court, along with the respective counsels.
Grateful.
Stays there. Stay shall continue till next date of interview. No, sir.
Number 46. Not case.
Yes, Mr.
Appearing for respondent in this case.
Yes. What happened to the mediation? Failed.
Transfer petition. It is failed, my lord. Maybe the petition may be allowed. They're asking for transfer of family.
Who are you? You are appearing for respondent.
Respondent husband. I have filed the divorce petition.
You are appearing for whom? You are Raghu or Vishwanath? Raghu. What do you want? How far is Nagamangala?
My only humble submission is to expeditiously dispose of this matter. The direction has been given granted to them. It's a second marriage for the respondent, my lord.
Second marriage for the respondent husband.
Yes, ma'am.
Then why are you now, have you preferred for divorce?
She has filed DV Act, my lord, and under 420, 498A, 504, 506, and DV Act, and acts also section 12, miscellaneous petition for.
Is there any child of from the marriage?
No, my lord. No, man. It's not consummated.
Don't want to live with your husband? Fail. Petition is preferred by the wife seeking transfer of the matrimonial proceedings filed by the respondent in MC number 31 of 2022 of Bengaluru. So file this petition for under which provision, Mr. Counsel, correspondent?
13 IM.
Stop. The petition preferred by the respondent husband is under section 13(1) for divorce against the petitioner wife. Full stop. The contention of learned counsel for the petitioner that he has preferred criminal miscellaneous petition under the provisions of the Domestic Violence Act in CMIS Criminal Miscellaneous number 569 of 2021 before the civil judge and JMFC at Nagamangala, which is pending adjudication. Stop. He also contends that he has filed a complaint for the offences punishable under section 420, 498A, 504, 506, 323, 149 of IPC, read with section 3 and 4 of the Dowry Prohibition Act in crime number 245 of 2021.
Now it is converted to 374 of 2022.
Charge sheet is laid.
Yes, my lord.
And a charge sheet has been laid in CC number
374 of 2022.
374 of 2021. 2, which is pending before the court at
Civil Judge JMFC at Nagamangala.
Delhi? At Civil Judge JMFC Nagamangala. Full stop. It is a contention of learned counsel for the petitioner wife that she is residing with her parents at Nagamangala Taluk, and it will be immense hardship and difficulty for her to travel to attend the court proceedings at Bengaluru initiated by the respondent husband for divorce. He further contends that the petitioner is unemployed and she has no source of income as she is depending on her parents. And there would be huge expenses for travel and accommodation if she has to travel from Nagamangala to Bangalore to attend the court proceedings, which would not be the case if the respondent is ordered to travel to Nagamangala to attend to this matrimonial proceedings, and hence he seeks for transfer of these proceedings preferred by the respondent husband at Bangalore to Nagamangala. To stop. He also contends that thereby the petitioner would be, it would be convenient for the respondent husband to attend to two proceedings initiated by the petitioner wife at Nagamangala. To stop. Learned counsel for the respondent is present before the court. He objects to the transfer of this petition on the ground that frivolous petitions are initiated by the petitioner wife against the respondent, and it is the second marriage of respondent with the petitioner. However, he is interested in expeditious disposal of the case. Full stop. Having heard both the learned counsel for the parties, I am of the opinion that the matter, if it is transferred, the matrimonial proceedings in MC 31 of 22, pending on the file of the family court at Bangalore.
Fifth additional.
Additional principal judge, family court at Bangalore, if transferred to the what court at Nagamangala it is? Senior civil judge and JMFC Nagamangala. So inconvenience would be caused to the respondent, whereas much hardship and inconvenience would be caused to the petitioner to travel from Nagamangala to Bangalore. Accordingly, I pass the following order. Petition is allowed. The matrimonial proceedings pending on the file of 5th Additional Principal Judge Family Court in MC number 31 of 22 at Bangalore is ordered to be transferred to the Senior Civil Judge in JMFC at Nagamangala for adjudication in accordance to law. The Family Court, the JMFC, Senior Civil Judge and JMFC in Nagamangala would make efforts to dispose of the matter expeditiously in view of the second marriage of respondent husband.
Oblige.
CP petition ಅಲ್ಲಿ ಏನು amendment? Huh? Hole Narsipura. She was resident of Hole Narsipura. Now she is transferred to. All right. Where is the respondent residing? So from Krishna Raja Sagara, what is that? Krishna Raja Nagara to Hole Narsipura. So you want the petition to be transferred where? Where are you residing? You have any objection? No, if we, huh? What is IA number 2? Berkeley. What is on IA number 2? This application is filed. Carry out certain amendments in this petition, the transfer petition. As during the pendency of this petition, the petitioner has been transferred to Hassan Taluk, Hassan district. As she was working as a principal in Moraji Desai Residential School at Palai Narsipura Taluk at Hassan earlier. And now she is transferred to Moraji Desai Residential School at Hassan Taluk, Hassan district, correct? Hence, the petitioners filed the present petition for incorporating certain amendments. The counsel for the respondent does not have much objections to the said application. The application deserves to be allowed, accordingly it is allowed. Petitioner is permitted to carry out the amendment by serving a copy of the amended petition to the learned counsel for the respondent. Amendment to be carried out. Okay.
48.
Davangere.
Date of taking interim order to not serve with the copy of the petition of
Huh? What do you could learned counsel to serve copy of the petition to respond?
maybe I have no objection for it.
Copy at least ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. So from Bangalore, you wanted to Davangere. All right. Work. Petition is allowed. The matrimonial proceedings pending, MC number 515 of 2021, filed under section 13(1)(1)(a) of the Hindu Marriage Act, pending on the file of second additional principal judge, Family Court, Bengaluru, is ordered to be transferred to the Family Court at Davangere. So, is there any proceedings pending in Davangere? What is that? Huh? 120. All right. That's in a different court. That may not. The family court at Davangere. What is the number? To be transferred and tried along with the criminal miscellaneous number 121 of 2022, pending on the file of which court? Which court? Only one day, na? With pending on the file of the family court at Davangere. All right. Accordingly, petition is allowed. This detailed order will follow. Notices served, unrepresented. What is the proceedings initiated by the respondent? ಅದು ನೀವ್ ಹಾಕಿರೋದು. What is the petition filed by your husband against you? Where is it? You don't want to join your husband? What petition you have filed? Yes, has appeared. Take out notice to the council. Learned counsel for the petitioner. Learned counsel for is permitted to take out notice of this petition, serve notice of this petition to the counsel representing the respondent before the court at family court at Hassan. Stop. Orders on IA number 1. There shall be stay of further proceedings in MC number 37 of 22 on the file of Principal Judge Family Court at Hassan till next date of hearing. Huh? IO. What is IO? Stay. The order stands extended. Serial number 44. All right. You're a resident of Udupi. Where? Custody. You have not filed anything. The children are residing with whom? How many of them? 6. We'll stay the proceedings. So that when is the next date of hearing? When is the hearing date in that court at Bengaluru? Yavagide. We'll stay it. Meanwhile, you take instructions. What is there? Learned counsel for the petitioner is present before the court. Learned counsel for the respondent seeks time. What do you want time for? What? All right. Orders on IA number 1 of 2022. There shall be stay of all further proceedings in MC number 1174 of 22, pending before the 6th additional Principal Judge Family Court at Bengaluru till next date of hearing. Relist after 2 weeks. What is it filed for? What? You don't want to join your husband? Huh? Have you filed any petition against him? Child is there. Heard learned counsel for the petitioner. Issue notice to the respondent. Have you taken notice in the petition filed by your husband? That counsel is also permitted to take out notice of this petition to the counsel appearing for the respondent before the senior civil judge at Sirsi. Huh? At Sagara. What is it? Page. At Principal Civil Judge and JMFC Sagara. Orders on IA number 1 of 22. 23. No, 23. That shall be stay of further proceedings in MC number 49 and 21, pending on the file of Senior Civil Judge and JMFC Court, Sirsi, next date of hearing. Guru Lingaya.
I prefer respondent.
Yeah, Gunashekhar, you are appearing for whom?
Respondents in both the appeals.
No, respondent yaro. Respondent andre?
Insurance company, my lord.
Insurance. You are for? Owner. So now the tribunal has fixed the liability on the owner. You have filed appeal to shift it on the insurance company. Yes. Case of injury. Let's argue.
My request your lordship to ask the advocate to please direct the mic, my lord. It's not audible.
Mic model. You are able to hear him? You are don't show a blank face. You say yes or no. Ridiculous. Are you able to hear me? Why are you showing a blank face? Are you prepared in the case? Were you able to hear your friend? Or ಹೇಳಿದ್ ಕೇಳಿಸುತ್ತೇನ್ರಿ ಏನ್ ಹೇಳಿದ್ರು ನೀವು ಅವ್ರು ಹೇಳೋದು ಕೇಳಿಸಿಲ್ಲ ನಿಮ್ಗೆ ನೀವ್ ಹೇಳೋದು ಅವ್ರಿಗೆ ಹೆಂಗ್ ಕೇಳಿಸುತ್ತೆ ಈಸ್ ಇನ್ VC. You can see him there in the screen. At least you take the mic up to your and speak so that he can hear you. English ಬರುತ್ತಾ ಇಲ್ಲ ಮತ್ತೆ ನಾನು ಹೇಳೋದಕ್ಕೆ ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ವಲ್ರಿ ನಿಮ್ಗೆ. You speak on the mic so that he can hear you and respond to you. Any difficulty? Argue. You're able to hear Gunashekhar?
Yes, ma'am. I can hear, ma'am.
15/6/2011. What is the age?
40 years.
What are the injuries? Have you examined the doctor? What is the disability? 17% to the whole body or limb? Which paragraph it is? Read it. Have you produced any income proof? No. Fully chart value ಬರ್ಬೇಕು. What is taken by the tribunal? ಎಷ್ಟು ತಗೋಬೇಕು? 6,500 ಆಗ್ಬೇಕು. Disability 17%. Is he a doctor who has treated the patient? He is not the doctor who treated. Okay. What is the 10 days inpatient? Disability certificate is at exhibit.
ಇಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋಂಗಿಲ್ಲ ಸರ್.
ಇದಿಲ್ವಾ?
ಇಲ್ಲ.
Cannot produce disability certificate. Only the statement of doctor. All right. Anyway, you're not challenged the disability.
I'm not trying. Because the tribunal has given, rightly has given as 10% on the ground that the fracture is united.
Whether the 17% what he has stated is to the limb or to the whole body.
Whole body, madam.
Only the whole body.
Yeah, it is on, sir. Yeah, evidence is on.
Evidence.
How did I have gone through the evidence?
Yes. Hmm. How many days you were inpatient? 10 days. How many fractures you have encountered?
2 fractures and 2 people injuries.
Wound certificate diya.
P7, madam.
P7. What does that say? P13. Adralli ಏನಿದೆ?
Upon fracture of the both bones calculated and fracture of the system.
Left leg fracture. So right leg and right ankle fracture. I mean left ಅಲ್ಲಿ ಏನಾಗಿದೆ? Right femur fracture. All right. Yes, next.
Femur right ulna.
Yes. So fracture of left femur and right femur.
Judgment prakara left, right leg, the left femur, right ulna. Right.
All right. Yes. Next. Pain and agony correct ಇದೆ. Medical expense correct ಇದೆ. Loss of income during later period, rest, nourishment. Future medical expense correct ಇದೆಯಾ? All right. Amenities has to be enhanced. Loss of income during later period will get enhanced. Yes.
Future income also will be enhanced because of the income.
Correct. That's all. Yes. Policy is there.
Yes, my lord.
Read.
And LL only learners and
Nimsha, Gunashekar.
I'm sorry, Marik.
Let him argue, then you can. Yes.
ಇವ್ರು ಮಾತನಾಡೋದು ಕೇಳಿಸ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಇವ್ರು ಮಾತನಾಡೋದು ಕೇಳಿಸ್ತಿಲ್ಲ. ಗುರುದೇವ್ ಪ್ರಸಾದ್ ಮಾಡೋದು ಮಾತನಾಡೋದು ಕೇಳಿಸ್ತಿಲ್ಲ.
Can pull it towards you some more. See whether it is on. Tap the mic. Tap ಮಾಡ್ರಿ.
Very ಕೇಳಿಸ್ತಿಲ್ಲ ಸರ್. State through mic straight up not some.
You have heard him.
I am. Weak ಕೇಳಿಸುತ್ತೆ ಒಂದೊಂದ್ಸಲ ಕೇಳಿಸ್ತಾ ಹಂಗೆ ಆಗ್ಬಿಡ್ತಾರೆ.
Then nothing prevents you from coming to the court.
ಸ್ವಾಮಿ ನನಗೆ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸಮ ಅದನ್ನು ಬರ್ತೀವಿ.
Yes. So he was the driver driving the car, is it? So he was sitting beside you.
You two were sitting beside me. He was.
No, what about the claimant?
Is a driver.
He was not along. You are in the motorcycle. You are a rider of the motorcycle. You are the offending vehicle driver come owner. You are having learner's license. Oh. Yes. All right. All right. That's the only ground. RW2. So you are RW1.
Before expiry of
So R2 is the DL. All right. Yes. That is all. Which is that provision? It uses the word accompanying or sitting next to you. Yes. That is not in dispute. It's to 3,11,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Yes, Mr. Gunashekar.
My lord, our the contention of the instance committee, there is a collusion between the owner of the offended car and the claimant. The vehicle in question had not at all been involved in the accident, although.
Regarding? That is okay. That I don't think there's any serious dispute on that. You can give the citation. Yes, Mr. Gudishekar.
Secondly, my lord, the offended, the rider of the driver of the offended car had no DL at all. LL was there, but he has not put it because of admission by me in the written statement stating that the offended, the driver of the offended car had no DL and had only LL. That was taken. He has not produced DL at all. as on the date of accident, there was no DL.
No, it is also his case that he does not have DL.
LL
He was
is there.
holding a LL.
LL is there, he has to be accompanied with a person who is having DL.
RW2 is the person who has DL, who was.
According to our case, this why he has been improved because objection in the statement has been long after taking notice. And he is not the prosecution witness. His presence is not found shown in any of the police documents.
All right, did you cross-examine RW2?
Yes, I have cross-examined.
Where is the elicitation? He was not there.
RW1
or 2?
RW1 he works with.
Yellide.
What thing, sir?
RW1 and RW2.
I am residing at Bangalore. I possess driving license to ride the DVTS. I have not produced it before the RW2 month.
ಯಾರ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ?
PW1 Swami. Sorry, RW1. Mr. Venkatesh.
RW1 is not Venkatesh. RW1 is Padrat Salamulam.
I'm sorry. Padrat Salamulam.
Yes.
So, it is true that I was the owner of a car. I was driving a car. It is true that at the time of I did not possess DL to drive the car. Witness was that I had LLR to drive the car. I have not produced LLR before the court. Witness was that at the time of obtaining driving license, I have produced LLR before the concerned RTO. Orally, I have informed the insurance company about the action, but I have not informed the same in writing. I have not informed the insurance company that one Ganeshan was with me at the time of accident. This is it is not true to suggest that Ganeshan was not with me at the time of accident.
It is not true.
Yes. I have suggested he was not.
Cut it, you can't see. Cut this.
Yes, I have not informed the insurance company that one Ganeshan was with me.
It is not true to suggest Ganeshan was not with me.
Company
but he has denied your suggestion. Continue further.
Suggestion. But to escape, it is not true to suggest that Ganesh was not with me at the time of accident. But to escape from liability, I am deposing false before the court. It is true that police have registered a criminal case against me in connection with the accident. I have paid fine in the said criminal case. I have given details of accident to the place. And at the time, I have informed that one Ganeshan was with me at the time of accident. Question: can you produce copy of opposite statement given before the police? I have to get it. Then I can produce it. I do not have any problem produce the same before the court. It is not true to suggest that I have violated the terms and conditions of policy, and hence I am liable to pay compensation to the petitioner. It is not true to suggest that Ganeshan was not with me at the time of accident. It is not true to suggest that accident was occurred on the middle of the road. My specific case is there is a collision between the owner and the claimant one. LL law, DL law, LL there was no one accompanying the claimant. Police, as your lordship, wherever. Yeah, our jotege police state complaint ಬಗ್ಗೆ ಗಣೇಶನ್ ಇರೋ ಬಗ್ಗೆ ಗಣೇಶನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ. That is the only ground I am having, and the tribunal has very well discussed about it and here first the liability only upon the owner. There is no any error on the judgment of the tribunal. That's all.
So, where is your cross-examination as against Ganeshan?
Yes, I have not given statement before the police, or I was along with the respondent number 1 at the time of accident in the vehicle. It is our first, I have not given statement before the police as I was along with the respondent 1 at the time of accident in the vehicle. It is not to suggest that I was not with the respondent number 1 in the offending car at the time of accident. It is not true to suggest that with an intention to help the respondent 1, I am giving false evidence.
Yes, denied.
Right. Yes, denied. He has clearly admitted he has not given the police statement to the police. If at all you are really with what is it, the driver of the car, certainly it would have been found in the police record. That is my humble submission. This is very well discussed and appreciated by the tribunal, and as such, the liability has been fixed upon the owner.
Yes. Yes. Any other document to show that Ganeshan was with you before the
Okay, just like that.
Tell there. What are you reading? Page. Yes. It is not true on the view. Yes, that's all. That's all. That's what. This appeal is preferred by the claimant seeking enhancement of compensation on the ground of inadequate and meager compensation awarded by the additional senior civil judge CT after referred to as tribunal. Stop.
ಏನ್ ಮಾಡಿದ್ರು ಇರೋರು ಬಂದ್ರು ಅಡ್ಮಿಷನ್ ಆಮೇಲೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ತಗೋಬೇಕು ಅಷ್ಟೇ ಅಲ್ಲಿವರೆಗೆ
The contention of learned counsel for the appellant claimant that the tribunal has committed a gross error in not awarding just and reasonable compensation. Stop. Tribunal is erred in assessing the income on lower side, ignoring the legal services, notional income of the legal services authority chart. It is also further contended by learned counsel that what is the multiplier taken? It's also contended by learned counsel for the claimant that the tribunal has committed an error in awarding lesser compensation on other heads, namely loss of income during later period, loss of amenities towards future medical expenses, and conveyance, and he seeks enhancement on all these heads. Stop. He also contends that the tribunal has awarded less amount of compensation towards future income that is due to loss of earning capacity due to disability. On these grounds, he seeks enhancement of compensation consequently to allow his appeal. Per contra, learned counsel representing the owner of the offending vehicle has also filed an appeal to set aside the order of the tribunal on the ground that the liability fastened by the tribunal as against the owner of the offending vehicle is illegal and erroneous, the same to be set aside and liability to be fixed on the insurance company. Full stop. Learned counsel for the insurance company, Shri R. Gunashekar, so present through video conferencing and contends that the tribunal is right in fastening the liability as against the owner of the offending vehicle for the reasons which are enumerated by the tribunal in its finding, which is appropriate for the simple reason that the driver of the offending car was not admittedly was not possessing a driving license to drive the car, and he was only possessing a learner's license as on the date of occurrence of accident. The contention of the owner of the driver of the offending vehicle RW1 and the owner of the offending vehicle and RW1 who's also a driver of the offending vehicle, that he was accompanied by RW2 who was possessing a valid and effective driving license and sitting beside him at the time of occurrence of accident is far-fetched and is afterthought which is incorporated by the owner cum driver of the offending vehicle only to absolve his liability and to fasten the liability on the insurance company. The further learned counsel further contends that if it was a case of the owner cum driver of the offending vehicle that RW2 was sitting along with him, nothing prevented him from saying so in the criminal records and the FIR registered before the jurisdictional police. On these grounds, he further contends that there is a violation of the terms and conditions of the policy and the motor vehicle rules. Hence, the tribunal is right in fastening the liability and directing the respondent owner of the cum driver of the offending vehicle with the liability. What do you say on quantum?
Quantum, my lord, considering the fact that this fracture has been united, the tribunal has taken as a 10%. The evidence is there that the fracture has been united. The disability given by the doctor is on the higher side. So the tribunal has rightly taken as 10%.
All right, good. Next para. Both the learned counsel for the owner and cum driver of the offending vehicle and the learned counsel appearing for the insurance company together in unison submit and contend that with the amount of compensation awarded by the tribunal is just and reasonable, and the same does not call for interference, as no proof of income is produced and tribunal has taken a notional income of 4,500, which does not call for interference. And the disability assessed by the Dr. PW2 is on the higher side, which has been rightly reduced by the tribunal to 10%, which also does not call for interference. Hence, the counsel for the owner of the offending vehicle cum driver as well as the insurance company sustain the order of the tribunal on quantum. Full stop. Having heard the counsel for the claimant, learned counsel for the owner, driver of the offending vehicle, and learned counsel for the insurance company, the point that arises for consideration before this court is whether the claimant is entitled to enhancement of compensation. Point number 2, whether the tribunal is justified in fastening the liability as against the owner of the offending vehicle and absolving the liability as against the insurance company respondent number 2, na?
Awesome.
Number 2. And whether the liability is to be shifted and fastened on the respondent number 2 insurance company. What order? Full stop. Having perused the entire material evidence, both oral and documentary, including the original records, I'm of the opinion that the tribunal is awarded inadequate and meager compensation, calling for interference for marginal enhancement of compensation. Full stop. The tribunal has erred in fastening the liability against the owner of and come driver of the offending vehicle, absolving the liability as against the insurance company, which requires to be interfered for the reasons herein mentioned below. Full stop. The occurrence of accident, involvement of the vehicle, injuries sustained by the claimant in the accident having occurred on 15/6/2011 are not in dispute. Hence, this court would not want to delve into the occurrence of accident and the negligence having been caused by the driver come owner of the offending vehicle, which is exhibited by virtue of the documents produced at exhibit P1 to P8 and the medical records at P9 to P13. Full stop. Now coming to the aspect of age avocation, income and quantum to be awarded by this court. Admittedly, age of the claimant is 40 years. The appropriate multiplier to be adopted is 15, which is rightly taken by the tribunal, correct?
Yes.
Correct is
Yes.
Is correct. Same does not call for interference. The only point is whether the income adopted by the tribunal at 4,500 is right. Admittedly, there is no proof of income placed before the court. In the absence of such proof of income, the tribunal as well as this court will have to relegate itself to the notional income produced evidence by stating that the claimant has undergone fractures, multiple 3 fractures, and the disability is assessed at 17%. However, the tribunal has assessed the disability to be 10%. I do not find any flaw in the tribunal assessing the disability to be 10%. Same is retained and not interfered. The loss of income due to the disability encountered sustained by the claimant would be 6,500 into 12 into 15. Calculate ಮಾಡಿದರೇನ್ರಿ ಯಾರು ಮಾಡಬೇಕು 6,500 into 12 into 15 into 10%, 1,17,000, correct? 1,17,000 would be the loss of earning capacity due to disability as against 81,000 awarded by the tribunal. Full stop. Para. Towards pain and agony, medical expenses, tribunal is awarded 75,000 and 1,22,276, which does not call for interference. Same is retained. Towards loss of income during later period, in view of this court, enhancing the income from 4,500 to 6,500 and the claimant having sustained 2 fractures, it would not be possible for the claimant to get back to his normal day-to-day activities unless there is a recuperation, for which he would require at least 3 months period for having sustained fractures. Therefore, 6,500 into 3 would be 19,500 as against 5,000 awarded by the tribunal. Towards loss of amenities, in view of the claimant having sustained more than 2 fractures, sir, 2 more than 2 fractures.
2 fractures.
50,000 is awarded as against 15,000. Full stop. Towards future medical expense, doctor? 50. Towards future medical expense.
ನನ್ನ ಪ್ರಕಾರ ಹೇಳಿದೆ ಸ್ವಾಮಿ, ಸಬ್ಜೆಕ್ಟ್ ಕರೆಕ್ಟ್.
Yes, Mr. Guruprasad.
ಇನ್ನೊಂದು ಆಪರೇಷನ್ ಆಗ್ಬೇಕಂತ ಹೇಳಿದ್ದಾರೆ.
All right. I deem it appropriate to award 40,000 towards future medical expenses, as the claimant would have to undergo one more surgery and also for removal of implants. Full stop. Towards food, nourishment, attendant charges and conveyance, he stated that the claimant was inpatient for 10 days. Which area is this? Which place?
2011.
Bangalore, huh?
ಇಲ್ಲ ಸರ್.
10,000 rupees is awarded under this head. Yes. In all, the claimants would be entitled to total compensation of dash as against 3,11,776. As per the table mentioned here and below. Next para. Coming to the aspect of liability, the tribunal has fastened the liability against the driver cum owner of the offending vehicle only for the reason that he was possessing a learner's license and not having a driving license. However, the tribunal has committed an error by ignoring the evidence of RW1 and RW2, and nothing material or contrary is placed before the court or elicited through the witnesses RW1 and RW2 to disprove the evidence of both RW1 and RW2 that RW2, one person, namely Ganeshana, who was traveling and accompanying the driver cum owner of the offending vehicle, was possessing a valid and effective driving license as on date of occurrence of the accident. It is also forthcoming in the evidence of PW1 in the cross-examination that two persons were traveling in the offending vehicle. It is not the case of the insurance company or the insurance company that the two persons were not traveling, and one of which was the driver of the person holding a valid and effective driving license. Full stop. As per Rule 3 of the Central Motor Vehicle Rules 1989, a learner's license holder is permitted to drive the motor vehicle provided he is accompanied by a person holding a valid and effective driving license sitting beside him or accompanying him while he is driving the motor vehicle. Full stop. In the present case, RW2 having come before the court and stated on oath that he was traveling along with the owner cum driver, that is RW1, which will have to be taken on the face value in view of there being no contra material evidence placed by the insurance company. Same will have to be believed and accepted. So also the evidence of PW1 supports the case of the owner of the offending vehicle that he was traveling with another person along with him. Therefore, the tribunal fastening the liability on the owner cum driver of the offending vehicle is erroneous, and the same is request to be set aside. Full stop. Admittedly, the policy was in force as on date of occurrence of accident, which is particular policy.
Yes, sir. Policy is another data.
Idea. What is that exhibit?
Card on judgmental.
Not place the policy. ಯಾರು ಕೊಡ್ಬೇಕು? ನೀವೇ ಅಲ್ವಾ ಕೊಡ್ಬೇಕು? You are admitting policy in force.
It has admitted, I believe, because statement of
policy
statement of
being in force, which is admitted by the insurance company, the same does not call for further delving into the matter, which is placed at exhibit R3. It's not forthcoming in the judgment at all. Which is placed on record as exhibit.
Judgmental, annexes.
Huh?
Annexes.
Annexure. All right. Therefore, liability is to be fixed as against the insurance company. Full stop. Accordingly, I pass the following order. Appeal is partly allowed. Appeal of the claimant is partly allowed. Appeal of the owner of the offending vehicle is allowed. The judgment and award passed by the tribunal is modified. claimant is entitled total compensation of dash as against 3,11,776. The liability.
Reduce the 6% mark.
ಅದನ್ನ ಕೇಳಿದ್ದೀರಾ ನೀವು?
10% ಕೊಡಿ ಸರ್.
Have you sought for in your grounds of appeal for reduction of interest? ಅವ್ರು ಹಾಕಿಲ್ವಲ್ಲ, how to reduce, why to reduce?
Because since it was in my favor, I could not file appeal. This is my request.
Enhanced compensation I will reduce. In Bardrim. Liability is fixed as against the owner of the offending vehicle as well as jointly against owner of the offending vehicle as well as the insurance company. Full stop. In view of policy being in force, the second respondent insurance company is directed to pay the compensation to the claimant. The entire compensation shall be paid from the date of occurrence of accident till realization. For the enhanced compensation amount, interest would be payable at 6% per annum. Full stop. You have deposited any amount? The amount in deposit made by the owner of the offending vehicle shall be returned and reimbursed to the owner of the offending vehicle upon proper verification. The entire records shall be transmitted to the jurisdictional tribunal forthwith. The entire compensation shall be paid by the insurance company within a period of 6 weeks.
From
the date of receipt of copy of this order. Page?
Application made by me in 2015.
So this is made into on 29/1/18.
Annexure B30 similar application to the job grant permission to start testing on suppose which is the 3rd of February 2008. But thereafter, page 21 annexure C. The relevant portion is page 32. B part is the top of the page is 32. Pharmacy council and permission let's see approval did not give you that, I did not say that should be careful to page 34 annexure D. This annexure C is 2018.
What is the date? What is the date of that? CC. June. Pharmacy Council of India grants.
It shall take up 60 days. Annexure D is 34.
What is the date?
Even for 2021, I did not admit students, I did not admit because I want the government product. But then,
this is annexure D.
Yes,
Earlier one was annexure C.
See now, this is the application 1920, this is dated 2009.
Yes.
This is code. Saying that the government order and very applications how many times page 44?
How many have you admitted? 40?
42 students. Petitioners 2 to 43 of the students of the grade. Have we taken 60, we taken about 42 students.
So this letter you have given to whom?
So we go to the reference fund. I will ask you to make sure your page. Miscellaneous with regard to the report, Miscellaneous 3/2/2018, not basically. My application of 3/2/2018 is referred here. Which I made for approval. Then you have to, not in respect of pharmacy institutions, right? The health controller has to inspect upon this inspection, government will give you order. I go back to the pharmacy once. But serial number 2, because health controller's report, which is also dated 26th of March 2019. But throughout 2018, I applied 1920, I had pharmacy council, I did not agree. 2021, I had pharmacy council, I did not agree. 2021, anticipating the government to grant me order. They granted me direct on 16th of February, not 16th of page 45. Operating portion, not this is dated 16/22. Not taking the approval for 22. My request was for 18/19.
So approval is given for 22 to.
But my humble submission is that throughout from 2018, I had approval. Security conditions for the students take up exams. 47 annexures. Page 47 annexures is the time table. Exams are scheduled to commence tomorrow 10:30. Because I go across the register numbers of the day. Study the result and the students take without having it. Throughout 2018, we are anticipating the government will grant.
Yes. Withdrawn. Where is that? No, Annexure C is granting approval. No? Page. Read it. Yes. Yes. So now he has made admission for which academic year? So no admission is made for 1920 or even before. So the admission that is made is only 21, 22. So permission is granted for 22-23 by the government. Yes. Hmm. Hmm. Are you okay, Mr. Counsel? No, we have to be sorry. I think you can maybe initiate against. No, sir. Like the change that stool. Yes. ಯಾವುದು?
Special Council of India.
Yes. That's all. It's your argument. Yes, what do you say?
In the academic year, 1890, children have not taken a lot of which proposals the above is
All right. Yes. All right. Yes, Mr. Ravi Shankar. You're also in the same similar case. Different. Then you want to continue this argument or you want to? In Ravi Shankar's case? They have given. Why? Now.
Written back to us, we do not respect. Therefore, we are not.
For which academic year he is seeking? Yes. All right, I'll give you time. You'll have it at 2:30. 2:30 I will hear. Preference will be given to this.
Court officer. Court officer. Serial number 20. Sir, quota 22 serial number 61 or 64 ಏನಾಯ್ತು sir?
61 60. ಏನಾಗಿಲ್ಲ ಇದೆ ಮೇಡಮ್.
Okay sir, okay. 2:30 ga? Sir, okay, thank you.
Hello. Hello. Hello.
ಹೇಳಿ.
Yes. Ravi Shankar.
Courses are kind of courses that there are multiple authorities towards sanction or replacement. Under the scheme of the Pharmacy Act of 1988, there are only two things which are confirmed. Number one, there is a requirement of approval being given in terms of section 11. The second one is regulations of section 12 of the Pharmacy Act. What is required to see is whether a given institution which is required to impart the information in pharmacy. Number one, the required infrastructural facilities. Number two, the required instructional facilities. But infrastructural facilities are how much space is there, classroom is there, laboratory, instructional facilities are
What is the present act governing? No amendment to that.
Whole object of the entire statute for the purpose of granting approval is to find out whether there exists the requisite infrastructure and the instructional facilities for approval. This is a bonus which is given to the Pharmacy Council of India. But Pharmacy Council of India, whatever they do, because of an imposition in terms of subsection 2 and subsection 3, more particularly subsection 2 and subsection 3 of section 1, it says that you will have to get the consent of the state government.
You mean that Pharmacy Council of India.
Pharmacy Act. Subsection 2 and subsection 3 of section 1. Subsection 1 deals with the approval of a course which is to be conducted by the state. Then subsection 2 and 3. Any authority in the state which holds
of subsection 2 and 3 of
section 12 of the Pharmacy Act. Page number 7. Bottom of the pages, page number 7.
Yes.
Subsection 2. Any authority in the state which holds an examination in pharmacy may apply to the Central Council for approval of the examination. The Central Council is satisfied with such inquiry and the said examination is in conformity with education regulations. Shall declare the said examination to be an approved examination. Subsection B. Every authority in the state which conducts an approved course of study or holds an approved examination will furnish such information to the Central Council may from time to time require as the courses of study and training and examination to be done undergone. As to the ages at which the courses of study and examination are generally as examination. Subsection 1 deals with a course being approved. That means there will be authorities in the state. Now the state is a board. If there is a particular course approved by the Pharmacy Council, but that course, an approval is given by them, then the requirement is to find out as to whether the examination is correct, what is and whether it is in the approved course. This is the only scheme of the Act. Then what happened? As a matter of practice, the Pharmacy Council said that since there is a requirement of compliance with this subsection, if we take the consent of the state government, it's a consent. It's the nature of a consent. There is no, the scheme of the Act, the state does not fit itself anywhere. It's a consent to be given by them so that these two requirements need not be done year on year or whenever the examinations. What they do is they will give us the permission for conducting the concerned course, which is the approved course. And then they say that within this time we got the consent of the state. Because once the Pharmacy Council approves
that we have the necessary infrastructure and discussion of STPs. The state cannot take a different. There cannot be. Actually, if there's a different opinion, certainly the state can bring it to the notice of concerned authorities. There is a case where Pharmacy Council constituted a committee, they conducted the inspection, said that we have the requisite infrastructure respect of the space, and granted as an order of what's subject to consequences. We have to obtain the state government. We went to the state government. In 2018 itself, the state government directed that the controller of products, who is the competent authority, because even under the scheme of the act, the state council will be headed by the controller of products. So he constitutes a subcommittee. The committee visits and then gives a report. By the time the report is given, it is found that 1819 is supposed to be coming to an end. Therefore, the committee says that let it be given for 1920. Then again the matter has to go back to the state. The board is one of the because the examination conducted, which is now read. Board is another authority constituted by the state which was conducting the exam systems. They are also required to give this test. So what they do? They say that it is for the years 2019-20 this can be done. It would not be permissible for 18-19 because cannot be any admissions. So now all the three authorities concerned, Pharmacy Council of India, the inspection conducted by the state government, and number three, the board. All three confirms the fact that we have the necessary infrastructure and inspection. It's required to be done is just take a decision. In the case we are consulting, because are already there on that table. What prevented them from taking a decision in all these years? This is not the kind of circumstance which is stimulated for the first time. State's laxity has always been a matter of concerning many matters. It's in a matter of this nature, we want to suit it. Because this is pertaining to a medical patient. The Supreme Court said, 96 just to make a prima facie case because the systems are admitted.
In that other case, not in this case. In that case, in Sarvana's
This
case.
is in 65.
It is number 89 filed. What is the party name?
It's Al-Karim Education Plus versus State of Bihar. Yes. Paragraph number 11. This was also a case where there was a laxity on the part of the state. Earlier, medical council had to give the approval and the consent was given. State for the purpose of granting an application. So then that was a case of here the approval was given. They have a paragraph number.
Yes.
The matter of grant of application is ordinarily for the state government of consulting medical council to arrive at a decision. However, if it is found that the application is being deferred unreasonable or the decision is being drawn for one reason or the other, this court would go reluctantly because it is inside the jurisdiction. Must make it clear that we are not diluting the importance of the essential set by the medical council for granting recognition. Facts in the case are very special, except in the present case we take all the following aspects. So, other areas, the applicant institution granted every application says more than 3 years, this court directed the students to be admitted and permitted to take the examination. View of the earlier office, they should submit for consideration. So I not read the entire thing. This was a case where it was pursuant to the directions given by the court that the students they were permitted. But here is a case where there was no interference by the court in the present matter. They have acted by themselves. Every single medical is on the table. It's not something which is not present before. What is the date my exhibition? Yes, WP number 165 of 2013, 2023. Page number 17. Page number 16, if you are not just for saying, this is the constitution of the committee.
Page 16, Anashar B.
I'm sorry, pages request page 15 for a moment. Because this was actually approval given on 36, 2018 itself. Sarkar in the upper Aushadhi Kendra, additional drug controller, where the supplementary so like And then it's number 17. It's last paragraph. So there is some deep format was he cutted the ಸೂಕ್ತವಾಗಿರ್ತದೆ ಮತ್ತು ಅದು ವಿದ್ಯಾರ್ಥಿಗಳು ಪ್ರಥಮ ಕ್ರಮ ಪ್ರಗತಿ ಸಾಧನೆ ಮಾಡಲು ಬೇಕಾಗಿರುವ ಎಲ್ಲ
for 18-19. But you did not make admission for 18-19.
On 27/9/2019.
Yes.
At the page over at page number 20. Suddenly ಸಂಸ್ಥೆಯು ಎಲ್ಲ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ಹಾಗೂ ಇನ್ನಿತರ ಅಗತ್ಯಗಳನ್ನು ಪರೀಕ್ಷಾ ಪ್ರಾಧಿಕಾರ ಮಂಡಳಿ ಶೈಕ್ಷಣಿಕ ವೇಳಾಪಟ್ಟಿಯ ಅತ್ಯಂತ
ಇಡಬಹುದು for 1920. 1920 is can be granted.
Then the pharmacy councils were expect they are produced at page number 21. This is the decision taken on 5th of June 2020 for successive year itself. Serial number 48. This is the petitioner. Latest information on recording, including the accurate based consideration for 2021 for Karnataka first year. We have not made any admissions for 2021 also because there is a recommendation of the board.
You have not made for 1920 also.
We have not made. 2021 also we have not made. 21-22 we have made it to all the earlier. It should also understand that nothing comes to your cost development of the activities. And they conduct the inspections when they are undertaking this exercise of approval and consent. This entire investment will have already gone in.
So you got permission now for 2021?
Yes, 2021 I have got it. Now 21-22, once an approval is given under the scheme of the act, there is no question of visiting the revisiting the approval. There is a problem for recall of the approval. Consent is in place. The scheme of the act never provides that once you give an approval, it can be made conditional, it can be withdrawn. All these functions like this there. But there is no statutory sanction. Now approval is in place. The entire materials is in place in their hands. That there is entire infrastructure and instruction it's available for 18-19-20. At this juncture, the state didn't take a decision. But it's only consent. It is not some kind of approval to conduct the course.
So now you have the permission for 2021 only.
Yes.
Not 21-22.
2021, once the permission is given, then the procedure for the purpose of withdrawal of the permission and approval is under section 13 of the Pharmacy Act.
All right, now you have permission for 2021.
Permission is granted. For all next.
All right.
Approvals.
For 2020-2021, you have the permission.
This one is the
Conditional.
We have the approval.
All right, approval. Have you made admission?
For 2021, we have not made admissions. Because by then what happened? The state had not given the consent. One of the conditions.
For which year have you made now admission? For that, do you have an approval?
Now, it's page 24.
But there's no point going to 2021 because you have not made any admission.
It's 2021-22, sir.
Page?
Page 24. This is the status which is reflected.
Pending.
Yes, the reason why they are showing it is pending is because consent is not yet uploaded by the state government. They are not. Discussion and therefore after the petitions by they are given, so people are making a statement on instructions. As a matter of fact, it's not necessary to seek consent of the institution for conducting the inspection. It's the power of the state government. They can just walk in without even informing us. That is the way they should. Sometimes they should come, visit, and then they will get surprised with things in place. That's the way they should. It's not the way they are referring to. If you are just going to see that endorsement, last one. ಕೇಂದ್ರ ಕಚೇರಿ ಪತ್ರ ಸಂಖ್ಯೆ 30/12/22 ಸದಸ್ಯರ ಪಾಲಿಕಾ ಮಂಡಳಿ ಪತ್ರ ದಿನಾಂಕ 28/12/22 ಸರ್ಕಾರ ಪತ್ರ ಸಂಖ್ಯೆ ನಮ್ಗೇನು ರೆಫರೆನ್ಸ್ ಇರ್ತಾ ಇದೆ. It is not referred because of the sufficient resource may be prevented. It's no question of preventing. If the inspection team comes to my place, I have prevented them.
What is your prayer in your?
We have the approval for 2021, approval for 21-22 is getting consideration. Circumstances are never as not. Everything got is because the policy council also find it difficult. We are in a dilemma where we are putting the complete investments for preventing institutions. Admissions were made because entire materials were already.
When is the examination for the students of your batch of 21-22?
Same batch. Same batch. No, I am making a statement. You are not just going to put the institution on terms. But in the event we are failing, if any inspection is conducted by them and they find there is any lack of infrastructure inspection, let them give you an opportunity because they may have a ticket. Because consistently taken by this one will put various. If the deficiencies are curable, give them an opportunity. They will cure it within a reasonable time. If they don't cure it, then impose exemplary costs.
Which is the provision which says? Which is the provision in the act which says that you can be imposed with cost or penalty?
So this all the event institution fails in ultimately succeeding in the recognition by virtue of which we are now seeking release. The students will have to be compensated for this. So it's ultimately the students. Students will have to be compensated. The institution will be very huge cost for the purpose of ensuring. I'm making a statement on instructions that this is an institution which is having the necessary infrastructure instructions. Also, 2 years. Because ultimately, the educational empowerment which is required should not be struggled due to the administrative delays or the administrative batches. These are the kind. I am in a position to demonstrate before the court that there is a lack of the facilities to be extended. Because ultimately, these approaches are given so that there is an educational empowerment of needy students. They will get employment opportunities. This is the work. But at the same time, what the Supreme Court allows, they should not be educated in such kind of institutions which lacks basic infrastructure or the inspection. If this is taken care of, then the student should not be. Now it is. Giving the examination, because all the results will not be secondly, we will not claim any equities in the matter. It is between the date of conducting the examinations and the results of the next year's admissions. Let them conduct an inspection of the institution. If there is anything they say that this is missing, I will make it everything. Let the institution of this kind of it's the institution is surprising. The last one, I'm sure the will make good qualities. Bring about an education institution. It's a very painstaking exercise. Not easy. Everything in place and to bring about an education institution is not at all easy. But when we do it, this the government should see is an empowerment of its own citizens. We are giving them an opportunity because they will provide us an opportunity for the education. These are the kind of cases where some kind of extraordinary that's the reason why. In some cases, your access may have to exercise the powers of the right. So I am putting myself on terms. That was a case where the Honorable Supreme Court permitted everything to be done. Supreme Court itself permitted notwithstanding the private patient, but I am saying this. If ultimately, if it is found that I have made an admission without infrastructure, you are may put me on terms as to leave us in the first because 1 year on a student secretary career suddenly works out. Take it at risk. I should not have been taken at risk. But state government, it was just everything was on paper. It is just saying that everything is there on paper.
Yes.
Let's not be affected.
Second. No, that is admitted. That is admitted. He himself, that is why he is it is for approval. Correct.
Is withdrawn. Restoration.
Where is withdrawn?
See, these are 6 for restoration. Prayer only, second prayer.
Huh.
Where the issue rate of appropriate future of minor directing the and continue the actual order to the petitioner for any the pharmacy workers. How they accordingly care for the
Yes.
no approval at all.
Yes.
If there is no approval, then the students, even if they undergo, sounds like for entry models to do the right things. The result will be given for the again, registration will be.
Yes.
This is what is happening. There is no approval at all. Government has not given permission, examination body has not given application, there is no approval. In spite of it,
You don't have a provision in the Act for awarding a penalty and compensation.
under section 13. The members are under approved rules, approved examination. Examination also approved. Registration will be under section 13. Approved by the government. Yeah. Examination.
Yes.
That is not there, they cannot practice the pharmacy. Have to practice pharmacy, they should practice the pharmacy. If course is not approved, examination is not approved, then it's supposed to be. This will be.
Why do you take such a long time to grant approval?
Conducting of course is not approved.
What happens to the career of the students?
Institution has to pay for that. The institution is neither the.
Now, what are the deficiencies according?
There are no deficiencies at all. Only the condition is that the should be section 2. Be for conducting application is not there. Section 2, section 4, and also the examination. Also say that yes, it is. That application is not there, then how the examination is conducted? What is not given approval? Somebody recommends.
So you are a recommending authority. Your state is the recommending authority. So
State gives the permission. Application will be by the board of examination or D pharma. D pharma, they have no and this one there is application. Application.
no, but no.
Petitions are only in some cases where the institution has to conduct the course in accordance with the because there is a requirement of application being granted by the institution. One of the courses are the concept of application is not but what is recognized is approval and consent. The number of applications because this kind of government is a very loosely used. The construed in accordance with its legal partners, applications is not arise. We are getting ourselves bound over by the nature of course which is required to be conducted in accordance with UGC
according to the university guidelines. It's how they were set. It's not the nature of courses for which there is already a set guideline. Which is prescribed by the policy.
Correct, but the fact remains that without approval, you have made your admissions.
That's why I said approval is existent. They have a message coming from amendment.
Yes.
Because these kind of practices are there, you know, you don't ignore the fact that these practices are there, but they are not really there. Where the executive committee reports the Senate consider an approved course of study or an approved examination. Central Council shall give notice to the authority concerned of its intention to take into consideration the question of withdrawing the execution of study or examination as at the said authority because of the receipt. This is the procedure
No, that is only for approved course of study.
This is for approved course of study and the examination.
That is not at all granted to you.
That's why I'm saying. No dispute about the fact that there is an approval for 2021.
No. You have been granted for 20 to 2021. You have not made any admission.
What is contemplated in the scheme of section 1 and 13? The last is going to see 12 and 13 together. Never contemplates an annual approval. It contemplates an approval as such. And the situation of withdrawal of the approval. These are the two concepts recognized in the system. If they really wanted to withdraw, the approval granted under section 12(2), which is repeatedly granted, they have to follow the procedure of the section 13 which they have got over. What they would do is, they will, when giving an approval, they will impose a condition. Consent should be obtained from the state. The state government will give the consent based on the examination. State it's an authority. Subsection 2. It's not the state as such. The state is only like the mouthpiece. There is nothing more which is required to be done by the state. Any authority in the state holds the examination. In the pharmacy, the state. What is the scheme of guidance? Examination says that this is what's available. It's a matter of practice. It goes to state government. State government will say they are doing this. Was the scheme of the so I'm not saying that you must say the first. The last I go. This lines in right. Thanks. But as I put in simple circumstances, is taken a view that all authorities concerned should take simultaneous decision. One authority cannot delay the process, and that must be by a standard provision. Management would be legally entitled to it. There is no dispute about the fact that the Supreme Court is and withdrawal limits is not some kind of a matter of course that I am not happy with the fact that the consent is not given by state government. There is something for us. If you are asked to the impossible, the state government, I can catch out of the state government standing giving their consent. To impose a condition on me, I am not capable of performing by myself, but it's dependent on the performance of the third party. The third party that the state does not perform, you cannot realize me. Or no point of while I should not be realized this. How the jurisprudence is developed on the concept of impossible. Therefore, I'm only saying, in case I falter, if I don't have the infrastructure, they are connected examinations. The process may impose costs for the purpose of both admitting the students so that they 1 year of academic career or 1 year. I don't want the students to.
That is pending disposal of the writ. Suppose this court is not accepting your argument and dismisses the writ.
Yes,
No, that is why you should make an amendment into your act. I think that this amendment is there in the other NCIM, or what is that other one? Why don't you do that? Well, first thing is you don't do your job on time. No, for the academic year 18-19, You give your approval in 2021. No. He has applied in 18, sir. You give it in 2021 you give. What is the purpose of him establishing the institution? Please, sir, sorry, the mindset of the state and council, you are thinking that everybody else is an enemy. You have to understand that is why our country is lagging behind. These are private investors into the education system of the country who want to establish education, impart education to the students. You have to be proactive and give your approval correctly on time. You go and cancel the approval on time before they commence the admission. No, for 2018, you give approval in 2021. What is the fees that you pay for each take here for each student? This again is going back on the judgments of the apex court in granting permissions to our institutions which are not approved.
89,000 is the course.
Yes, you want to see?
19. So, they cannot by giving condition. Here the standards of these so in 1920, the commission, all along there is no petition. So without permission, without is not allows after admitting the students to lost. I just read one paragraph of it.
In which case? Yes. Yes, please. Extraction. Yes.
Law declared by the orders should not be granted as a matter of particularly in election matter where standards of distance granted. That's the same on right here. Direction. For grant of basis direct admission of shall get to get approval from authorities results or permission and not be granted.
Yes. This is of the year. No, what you read is 2004. What you read is 2004, but this dental council is 2017. I think pursuant to this, there must be that case of Ranvijay, I think.
The regulations will provide that this is the necessary infrastructure, these are the expected. Every time the court is emphasized to ascertain as to whether this is there or not.
Correct, but time and again, the Supreme Court says that the High Court should not grant interim orders because this is going to grant.
But there are cases. Yes, process. Not even an inch is old. Every single authority is recommended. Every single authority. Not change, not let it matter. Eventually, they got only answer is that why they were standards. We are the part.
Problem is, I cannot go against my own judgment sitting in a division bench. I think in the sitting in the division bench, I have myself held that where there is no permission granted for whether pharmacy or Unani or Ayurveda or medical or dental, the previous years automatically does not get sanctioned if the future years are granted.
But those are the cases I just want to provide a distinction. Whether it's in Ayurveda or Unani or modern pattern. It's a requirement of knowing. First year, I should have the requisite infrastructure only for first year. They come in the second year, then I should have it for the second year and the first year more. This is how the regulations are schemed. Because Ayurveda, medical course, everything. Here is a case where I should give everything in one go. There is no question of installment. That privilege is not given to us when it comes to pharmacy. But those are the cases where the regulation specifically provides year on year. You are not complying with it, then it's stopped and go around the process that it has to get. Other institutions, how the regulations. Here we are not on the surface. There is installment basis partners. We have the give it in one go, which they have done. So I can understand if there is no material available. There is an approval, they say that now with the consent, therefore we are withdrawing it. On the kind of withdrawal system, the law. And infrastructure is in the infrastructure, the insertion is available. They should act proactively. For one sentence they should make. 2018, the recommendation is made by the board to the state government. And this is the reason why we should not act 2018.
What prevented you from filing a writ petition for mandamus?
2018-19, after this was recommended, then we have to go back to the pharmacy council. Pharmacy council in the meantime said that since you have not got a consent, we made one more application to pharmacy council. Again, on the pharmacy council approval on consent of the total pharmacy council approval now goes. This is the situation.
No, but what prevented you from approaching this court earlier rather than 11th hour?
The state government.
At least this court would have passed an order asking them to inspect and see the facilities and grant you.
Yes. State even now says that we are ready to consider it, but there is no reference to any of the letters here. They say that we want to consider it, but we are not considering it for some reason. In other words, the state could never refuse, especially with arrivals not with some refusing that we understand. The state is not required to do anything in the matter like this.
Only the state is the authority which has to approve it. Give a consent. Consent.
This is a practice which is done. But if one must strictly understand section 22, it is not the state. Any authority of the state which is conducting the examination, they are required to take that. But it's the board assets, examination board assets, required to give it. Board has given the approval. Because I refer to those two recommendations made by the board has given the approval. Therefore, this pharmacy course stands at class distinction with what is required under the medical education. Because there is a requirement of year on year monitoring. We give everything which is required for the second year also in the first year. Which they have confirmed. I can understand if there is no material that we have no college, there is no institution, there are no classrooms, no laboratories, no teachers. That's I am prepared to stand before buses and people. It is a case where something has been done. Eventually, because I am saying that the standard of education, all these judgments are because it is to ensure that the standards of education can never be compromised. Because my educational standards where the instruction imparted to me will be tested by the examination board.
Yes.
Availability of all the so everything the object is
Yes.
therefore, not so much intelligence heavy equal to safeguard the interest. If not safeguarding the interest, but we have to take the examination, of course, standards are exposed to examine number one. Secondly, eventually, like we have interest, I will compensate the first has to compensate. I'm standing up before your answers, not only for the instance, but also for the students also require to be compensated in 1 year as well. Therefore, I am conscious, standing here notes, I'm making a very conscious statement that institutions should also be responsible. But these are the kind of cases where some reasons are existing, where the laxity is not on the part of the institution, but it is on the part of the administrative delays. Some intelligence at what that
You have not given the approval for what reason?
Conditions that affiliation from the board of examination, the consent of the state government. And that is the condition was for the time of granting the approval. If you do not produce within certain period, you can bring to the. They did not produce, and they did not advertise. Next year also the same thing. Now we hear for this thing and for 22-23 permission.
So those two conditions are, one is they have not taken from the board of examination. Board of examination. But these are not curable. These are not curable. Yes.
Page. The karma. State governments, some third case are requested. They to pharmacy. NOC of the state government.
Just often we as per the definition also, regulatory bodies concerned are the grant of approval, the approval process by 10 days. Process by 21, 22 are yet to know.
Correct.
Subject to that, let the state verify. We have all the admissions. Prior to that date, we have given the full instructional facilities to the students. They are having the issues with attendance. They have been exposed to the laboratory exposures. Everything is done.
Right. You have done everything but two which are necessary. That is NOC from the state government.
State governments will examine the parties and requested to complete the process. The interest of the state government, because if it is something which is directed against me, I will be more than happy to do this. If something is in my control, I will do it because I can do whatever is in my control. That's the reason why it's not imposed here. Cannot be imposed upon me. But there are various circumstances where your actions impose conditions. This depends on the performance of the third party, over whom I don't have control.
No, if you do have control, you could have filed a petition for mandamus.
This is not a case where they are ready to consider. What was required is even now, based on the recommendations of the board, there is no other independent. It was easy for them to say how the data. Evidence are available on the file. They need not say that I want to not see. Once again, it is there in your on your file. It is there.
Why you did not approach this court earlier and you have come to the... No. The fact remains that the approval is not given to you. You could have come before this court asking for them to perform their act of approval, granting approval.
Objections and consent from his authorities. What is required under the Pharmacy Council Act? The approval by the pharmacy.
See, Mr. Senior Counsel, it is very sad, but again, heartening for the court also many times in these kind of matters where you have seen time and again for decades, these courts are lenient towards the students on the ground of sympathy.
I'm not saying for because I'm saying the ultimate objective is to ensure that the standards of education are not compromised. The standards of education is made an assessment of on the basis of how I impart the instructions, how they are held in their examinations. At the same time, I should have the necessary. This is something which is already there on record. Honestly, it is not there. If the authorities concerned have already said that it is there on record, nearly because one single word is not used by the state saying that we are considering. Ultimately, eventually,
When is the exam? Tomorrow? Tomorrow at what time? What can, all right. Now, can you do something to go and inspect and see today and secure permission or obtain consent? See, I am agreeing with you that he has no permission, he has no approval. Time and again, Supreme Court and this court, including me in the division bench, have held that where there is no approval, they cannot be granted. Simple as that. But here now we are dealing with students who have already completed 1 full year. I think they are writing the final exam of the 1 year. Whether you can do any inspection and grant approval by end of the day and then permit them in the morning to at least take up the examination, check up with your. You can check in, take instruction. I'll call this matter of half an hour.
There's no further discussion. I not go back to the government after. I have the notification. Only thing is not 21, 22. I have everything in place. I have the government order. Pharmacy council also kindly approval now, subject to the government.
The government has given you permission. No, that is given for 22. No. If your government order is for the year 2022, 2023 for 60 students, but you are not. No, you are seeking for admission for which course? Huh? Previous year, again you fall in the same bracket. You have the government. Please understand, you don't have the government. Not for the previous years. Please again, see, understand, you have the order from the government for 22-23. That doesn't mean you get a back retrospectively. That is, I think, find out, madam. See, one more thing is, I think like in the other courses of that NSC, ISM or something where penalty is ordered, you can initiate gradually and rectify the institution over a period of time and then come to an end that yes, no. Because now Supreme Court and this court also time and again has said that they cannot be approved for respectively or previous year merely because the future has been given. So you have to gradually rectify them. You can't overnight rectify them. Impose costs, let the government recover costs from them and then do it. It's not forthcoming in the. All right, you sit with madam and you find out, madam, from your chief secretary or principal secretary, whether whoever is concerned. If you can do something, because it is not your case that they don't have infrastructural facilities or faculty being lagging or library or academically they're at flaw. The ground for rejection is only no objection from examining authority and the consent from the state. This is a curable defect. Correct. Now we are in a situation. All right. By virtue of a court order, you can do it now. Because this court cannot go back on the orders of the Honorable Apex Court, but we can give a direction to the state to complete this formality so that the students are benefited by tomorrow or postpone that, or that I don't know whether that can be postponed. It's too late. So find out whether it's possible. Otherwise, they are left with no other option.
Wherever the students examination, we eventually found that the college and special examinations are direct to be considered. But even for medical students, it's the nature of orders which is passed by.
And we are again creating some precedent which this court should not interfere in educational matters. This is what is the courts cannot step into the legislation of how the examination has to be conducted, how the approvals have to be given. All right, find out. I'll call this matter at 4 o'clock. Find out. Just see how you can be beneficial for the students. Yes. ಎರಡು ಮಾತ್ರ ಬಂದಿದ್ಯಾ ಯಾವ್ದು ಅದು ಎಜುಕೇಶನ್ ಇದೆ ಇಬ್ಬರ ಹೌದು from the government but otherwise then you also mentioned this to the learned AGA and no, who has not put it in the portal? Yaro. PCI. That is state only. Huh? Engineering. B1.
The petitioners of the
Yes. On 5th January. What is this 19 annexary
File number 2 large. Respondent number 1. Board of examination.
When is the examination? 14th. Ah. No, 14th is the second Saturday. You have exam on that day. When is the what are your subjects and when is your exam start?
Before the last, once the analyze of the exam answers, the issue announced on the board.
Who appears for this respondents? State. And R2 is the Ramaiah College. All right, you take out notice. We'll call this matter tomorrow, day after. Today is 10th, Allah. Take out notice. Heard, General Counsel for the petitioner, Leonard AGA, directed to accept notice on behalf of respondent number 1 state. Issue notice to respondent number 2. Who appears for Ramaiah? Any counsel is there? Leonard Counsel is also permitted to deliver hand summons of this writ petition to the second respondent. Release this matter tomorrow. Nale ಬರುತ್ತಲ್ಲ madam? Report on the state. Notice of this petition by way of hand summons to the respondent number 2 college. 53, yeah. Yes. Yaro. They're not interested in these matters. They're not interested in 2013 matters. You want to keep it for another few years. All right, release this matter next week at request of counsel for appellant. Mr. O. Mahesh. Girish. O. Mahesh. None appears for either of the parties. Released after 2 days. Grateful. Released on 13th. Same order. Ariga, Chandrakant Ariga. Same order. Satyanarayana. 56. For appellant. For payment or owner? You're ready? You're ready to argue? What happened? The other side is divisional control. KSRTC idhar alla yaar. Renuka appears alva. You will direct who are the others along with Madam Renuka for KSRTC? Huh? Who comes regularly to court? BL Sanjeev. Arkole. Respondent. Respondent has been served but unrepresented. It is seen that respondent is none other than the KSRTC Corporation, who have panel of lawyers to defend their case. Hence, Learned Counsel Sri BL Sanjeev is directed to accept notice on behalf of respondent, registry to show his name in the cost list, counsel for the appellant to furnish one set of copy to him. So we'll list this matter next week. Next week. Huh? You can serve. I've ordered you to serve. To Sanjeev. Srinivas.
Harini Shivanand for R2.
None appears for either of the parties. Released next week. Raghavendra. TB Raju. None appears for either of the parties. Released next week. Pujari. Claimant. Injury case. Claim petition is dismissed on the ground. Huh? Then if dismissal means our respondent is required. Whereas O Mahesh, though his photo is very prominently appearing in the screen, he is not here. Learned counsel for the appellant is present. No representation on behalf of respondent number 2. Who's R1? Why you sought for dispensation when your petition is dismissed? Your claim petition is dismissed. Insurance policy may be there, but insurance can take up always a plea of no liability being on them. Why do you seek for dispensation? Understand, sir, your petition is not allowed. It's dismissed. That is fine, because if insurance comes and they dispute the liability, and if liability is going to be fastened on the owner, then what happens to your case? Will not survive. Okay. Relist next week. No representation on either side. Relist next week. Suresh Latur. Unmute, Madi. Unmute. Unmute yourself, sir. You have to unmute yourself. Rajendra. There is Rajendra.
The claimant's appeal, my lord. Yes, my lord. Yes, my lord.
What happened? Petition.
In this case, I have challenged the liability as well as quantum.
It is allowed.
Yes, it was allowed, my lord. 1 lakh.
Where's your opponent?
Oh, my lord.
So it is allowed as against the owner.
Owner, my lord. Yes.
R2 is dismissed.
R2 is dismissed. Yes, my lord. But liability will come upon the insurance company only, R2. But there is a road roller for which there, as per the insurance company, not taken the policy for third party liabilities, my lord. But here,
policy,
my lord,
policy is there.
Yes, it is there. But
let your friend come and answer.
Yes,
Learned counsel Sri Suresh Latur is present through video conferencing. There is no representation on behalf of R2. R1 and R2. Relist next week. Tell him to come. If he doesn't come on next week, we will continue to pass some orders.
Yes.
Amount will be. ಆಗಿದ್ಯಾ? ನನ್ ಮುಂದೆ ಮಾಡಿದ್ದೀರಾ? ಯಾರು ಮಾಡಿದ್ರು? ನೀವೇ ಮಾಡಿದ್ರ? To brief me what you argued. What is the case? Death case. Yes, you were here when he argued. I should know. You know. He was traveling on which vehicle? Mini van. So you are appearing for the insurance company. But what is this car? Driver of car bearing KA 53. Same. So the FIR is against this very same car. That's a van or a car? It's a van. Omni van. So you are representing that. All that. So the FIR and charge sheets against the van. So he was an inmate of the van. So rightly he has amended it to 166. Before the tribunal or here? Permitted, granted. What is the compensation awarded? Yes.
So the case like but what taking the other way therefore tomorrow if I say sports I have to pay the entire I will be not in a position to return that.
Which is the other way?
Right.
All right. So the van has hit a lorry. So the lorry is unknown.
Market to get liability. And tomorrow not recover also. Therefore, the MSP is justified in holding that 50% I will not I'm not. I will agree that I am.
Now this would amount to composite negligence. Composite joint tort fees, he is entitled to recover against any one of them.
This case, entire liability is not I don't enough about remedy.
You have no other option. No, what is the other option now? He is entitled to recover from either of you.
He's entitled to recover from either. He has not made them parties.
He's not been able to trace him. That can't be, because two vehicles are involved. The very purpose of legislation of by virtue of Supreme Court judgments of composite negligence, either of the joint tortfeasors or both, he is entitled to claim. Now he has found one, he has got hold of you, so you pay. Hmm.
There will not dispute the finding that any partial negligence.
That is immaterial now. Even if there is contributory negligence, you will still be directed to pay the entire and recover from the other person. That is the law. You have to tell the law now to me. You are a standing stalwart in motor vehicles cases. Which is that judgment? Composite negligence. Yes, there are several judgments. That is the only thing. Yes. So now quantum. What is taken as income? No proof of income. 15,000 HP.
1,44,994. 12,000.
1 lakh?
1,44,994 per annum.
Yes.
Divided by 1 will be 12,100.
Yes. Yes. So that's not in dispute. Yes, income is 12,100. What is the date of accident? When is the date of accident? 1,234. Henry, can't you read? 235. The whole judgment is in Kannada. But in para 2 of your appeal memo, you say 23/4/2010 at 4 p.m. Appeal. 23/5/2010. Age of the claimant. Deceased, death case, huh? Deceased was aged 26. All right. Multiplier 17. Yes. How many dependents? Bachelor, 50%. 40 plus 40 plus 30. 110 plus 11,000 plus 11,000. No, that is 30,000 added. 15 plus 50. 40 plus 40, 80 plus 15 plus 50 plus 11. 10% of the conventional head pranay se thi. That's all. Future prospects. Okay, that's all. Yes. 16,940. Eight, 4, 7, 0. 17. 17 lakhs 27,880. Loss of dependency. 8470 into 12 into 17. $12,100 plus 40% is 16,940. 16,940. Correct? The calculator tanda lady, madam. Huh?
16,900.
940. Minus 50%. Plus not into. Minus 50%. 8470. To 12 into 17. 17, 27, 880. Is preferred by the claimant seeking enhancement of compensation on the ground of inadequate and meager compensation awarded by the tribunal. How much is the tribunal taken income as? Tribunal has taken the income at 6,000, ignoring what is the exhibit of what is the exhibit? Salary certificate exhibit here. Exhibit P1, despite production of exhibit P1, salary certificate showing salary of 12,100 per month. Same is taken as income. Tribunal is not awarded future prospects at 40%, which requires to be awarded in as per the judgment of the apex court in the case of Pranay Sethi, National Insurance Company versus Pranay Sethi, 2018. Age of the deceased was 26 years, appropriate multiple 17. What is taken by the tribunal? Multiplier in the appropriate multiplier would be 17 as per the judgment of the apex court in the case of Sarla Verma versus Delhi Transport Corporation. The tribunal has taken the multiplier calculating the age of the parents, which is erroneous, and the same is set aside. Age of the deceased has to be taken into consideration for calculation of the multiplier as per the judgment of Sarla Verma, stated supra. Accordingly, age being 26 years, multiplier is taken at 17. The deceased was a bachelor, hence 50% will have to be deducted towards personal and living expenses. Therefore, the loss of dependency would be 12,100 plus 40% is equal to 16,940 minus 50%, 8470 into 12 into 17 is equal will be 17,27,880 towards loss of dependency. There are two dependents, There are two dependents being the aged parents. Each should be entitled to 40,000 per head as per the judgment of Pranay Sethi, stated supra, and Magma. 80,000 would be is awarded under the head of consortium. Towards loss of estate, 15,000. Towards loss of towards funeral expense and obsequious ceremonies, 15,000 is awarded. Towards conventional head, 80 plus 30, 1,10,000 is awarded. On conventional head of 1,10,000, 10% is awarded of one block period as per judgment of Pranay Sethi, stated supra, which is 11,000. Stop. In all, claimant is entitled total compensation of as against 2,26,800, 31,000. I will pay. No, this the amount is correct. 2,31,000 as against 2,31,000 as per the table mentioned here and below. Full stop. Learned counsel for the claimant vehemently contends that the tribunal has committed an error in saddling 50% contributory negligence on the part of the driver of the unknown lorry, which requires to be set aside. Learned counsel Sri P.B. Raju, appearing on behalf of the insurance company, sustains the order of the tribunal on the ground that nothing prevented the claimant from tracing out the lorry and bringing or making the lorry as a party to these proceedings. No efforts have been put forth by the claimant to and make the lorry a party to these proceedings. Therefore, the saddling of 50% is right, and the same need not be disturbed by this court. The fact remains that two vehicles are involved in the occurrence of accident, and the claimant is only an inmate traveling in the van. Therefore, it amounts to a composite negligence involving two vehicles. Under these circumstances, the claimant would be entitled to claim compensation against the joint tortfeasors, namely the van and the unknown lorry. And he can either file the claim petition seeking compensation against both the joint tortfeasors, or against any one of the joint tortfeasors. In the present case, the lorry is unknown and not traced. Therefore, the negligence attributed against the van against whom the FIR and charge sheet is laid is not challenged. Charge sheet charge sheet must be filed against your vehicle because lorry is not traced. You see in that order of the judgment in Kannada, last documents, whether FIR and charge sheet is there. Filed against whom? Which vehicle? Number. Yes, Mr. Claimant, FIR is filed against whom? Now I now judgment baribe. Just come and stand blank.
KA53N 4950.
KA53N 1957 ಅಂತ ಇದೆ. 49 ಅಲ್ಲ ಅದು 1957 ಅದು. KA53N ಏನ್ ವ್ಯಾನ್ ಏನದು?
ಮಾರುತಿ ವ್ಯಾನ್ 4957 ಅಂತ ಇದೆ.
ನಂಬರ್ ಏನ್ರಿ ಮಾರುತಿ ವ್ಯಾನ್ ನಂಬರ್ ಏನು? You have written 1957 in your para 2 of your appeal. Commit all the possible errors and you want the court to rectify it. The FIR and charge sheet is also laid against the Maruti van, which is not challenged by the driver or the owner of the vehicle. Accordingly, negligence is proved to have been committed by production of Exhibit P1 as against the van. Therefore, liability is to be fastened against the owner of the Maruti van bearing registration number KA53N 4957, which is insured with respondent number 2. In view of the fact that the claimant can seek compensation against either of the joint tortfeasors and the Maruti van being impleaded and the policy being enforced, the liability be fixed on both the owner of the vehicle as well as the insurance company having a valid policy, insurance policy. Accordingly, I pass the following order. What is the claim you have made? For how much amount? In your appeal is partly allowed. Claimant is the judgment and award so and so is modified. Claimant is entitled to total compensation of 18 lakhs so and so as against 2,31,000 awarded by the tribunal. Which is the judgment? Papanna and Thimmar. What does that judgment say?
Basically, finding of maybe the MSCP certified in electing order cannot be applicable because even email application. As in case of composite and everything that
Here he is not, he's third party.
yes, he's third party.
So in that case, you must have been the first party.
This is not be applicable.
But, yes, according. The judgment relied by the tribunal in the case of Papanna versus Timmanna and others in MFA number 805 of so and so relied by the tribunal would not be applicable to the present facts and circumstances of the case for the reason that in the present case, the claimant is a third party who was an inmate in the Maruti van. Whereas in the judgment relied by the tribunal, the claimant or the deceased other deceased. That case involved the first party who was the driver himself. And the same will not be applicable to the present case.
Anthony versus Caroline, 2008 CJ.
2000?
2008 decision.
Latest is the 2018 mail, something is there.
So this is the followed. I think
No, that's a Supreme Court judgment, sir. Supreme Court judgment is there. I will take it down. Don't worry. All right. The entire compensation shall be paid by the second respondent insurance company with interest. What is the interest awarded by the tribunal? 6. With interest at 6% from the date of petition till realization. The compensation shall be paid by the respondent number 2 within a period of 6 weeks from the date of receipt of copy of this order. Yes, what else? Anything else, Mr. Raju? Yes, Jan, aged persons. And you can order for some, what is a deposit? No, whether tribunal has made any. We'll do the same thing. Whether apportionment also is made? Equally. All other terms and conditions stipulated by the tribunal stands intact. You should come prepared and answer everything quickly, not stand blank like this. What is this? This is mathematical calculation. And waste the time of court. Yes. With the Passover thing. Court officer, you have to either sit down or move. This court would not want to go into that aspect of imposing conditions, putting the students into trouble, putting the institution into a situation. That is only apprehension. That is why I am. Please understand, sir, you are arguing on your side for the petitioner whom you are representing. Any order that is going to be passed by this court is going to be referred across India. Please understand, this is the difficulty that we face. You show me you show me one judgment of the apex court which permits me to grant you interest. I will grant right now. Show me one judgment. What stopped you coming earlier? Or you come in the 11th hour? Forget about, don't repeat the history. What stopped you from coming earlier? You want an order now, or you want to take a chance in the final petition, final order of the petition? Because I'm not inclined. If you still want an order, I will pass an order. Because I will be brushing aside all the orders passed by the Supreme Court and across India, several court judgments of several states, including our own High Court, creating new floodgates. That is different. That is. That is different. There, 60 students intake permission was there. That was an increase from 60 to another 40, 100. That stands on a different footing, sir. Its choice is yours. Huh? There's 90. What is the notes of that? There's no scope for now consideration. All right, then we'll hear the writ petition some other day. Since no interim order is going to be passed. Mr. Krishna, see, I understand it. Courts are inclined, and we feel very hurt when we are not able to grant relief to the students, because the entire career of 1 year is law. You don't understand as an institution.
They don't do it now. The government is.
What stopped you from?
How they can accommodate some way, not understanding. You say yes, you are everything after 1 year now, already pursued. You can reconsider, take multiple restrictions, whatever it is. And the time being, steps are taken, don't time, expect for final, actually we can find out. No, I'm only frustrated. I'm not saying anything further. My only intention is we have everything in place, there's a demand, and there's an order as well. Of course, we cannot put they could even consider it. For them to do. Only
Heard. Learned counsel for the petitioner in serial number 19, I guess. 90. And learned senior counsel Sri, what Ravi Shankar is? DR Ravi Shankar on behalf of Shri Learned Counsel Saravana S for the petitioner, and Learned Counsel, Learned AGA for R123, and Learned Counsel SS Haveri for R2. Learned Counsel for the petitioners and the respondents have extensively argued on for consideration of interim prayer. For permission of the petitioners. In both the petition, students are there. Permitting the petitioners bar students to take the examination of first year D Pharma, which commences tomorrow, is it? Tomorrow, that is 11/1/2023. Full stop. This court is not inclined to pass any order, interim order. Considering the fact, you want me to say so? It will affect your for. That's all. No. If you are able to persuade the government and PCI tomorrow for whatever inspection or permission, and if there are other exams which you can take, maybe then you can try to come back and hold the first. All advice now. And you should say earlier before me dictating down. You list. Strike off that order. Relist this matter after 2 days. You can move. Huh? After 2 days. Yes, madam. Day after tomorrow. All right, relist tomorrow. End of the list matter also tomorrow, all along with these matters. Got it. Continue.
Okay.
63. What about 62? Huh? 62, I thought. Raju, 63. VC case. Injury case, huh? What is wrong? Hmm. 20%. Disability of? Doctor has stated. What is the age? Any proof of income? Have you produced any salary details? Councils in Bangalore need to argue a little faster in MVC cases, sir. It's just a simple mathematics. I think the people in Dharwad and Gulbarga are doing better. What is this? But to come quick and say this is the age, this is the income, this is the exhibit, this is disability, this is the multiplier. What is there in this MVC case? He will bandu turn martira page. whether he is the treated doctor. He is treated. Do you admit? Respondents, do you admit? He is a doctor who has treated the patient. What are the disabilities awarded by the tribunal as to? Yeah. 20%, 30%. Why it is reduced to 8%? 30% to whole body or particular limb? Huh? Which paragraph? Left lower limb antidiyalri. L1 vertebra, sustained anterior compression fracture of L1. Left lower limb, 30%. Who's PW2? What is his specialty? He is issued disability. PW2 issued disability. Issued by PW2. He's not treated him. Whether he has treated him. You know the difference between treated doctor and the person who was given disability. Are you agree? You also are blank like him. The blind leading the deaf. You want to get ready the matter and argue tomorrow? Mr. Patil, you are also not ready, I guess. He is not the treated doctor. He is only issued disability. Read the evidence of PW2. So liability is fastened on only the owner. So you are third respondent in the tribunal. So your stands dismissed. Let's read the evidence of PW2. No, what are you reading? From the judgment. That's not the way to read, argue a matter on merits in the final hearing, sir. That you're challenging that order. You are challenging that order. You want to sustain the order. No, you want to sustain the order of the tribunal, or you are challenging the order? And you are reading the impugned order. What's the point? Madan Modi. Why he has not given disability to whole body? The tribunal is more expert than the doctor. Okay. That is, if the doctor does not opine. All right. Next. Next. What is the income taken? Have you produced any proof of income? What is the income taken by the tribunal? How much has to be taken? Have you produced any document? Was working as? It's a case of injury, Allah. All right. Where is the document of income? Not money. Then you will come under the bracket of chart. Yes, what is the chart value? Yes.
Tribunal has wrongly shifted the burden of liability on the
Or hire and reward. You are traveling in that vehicle, which is a Tata Sumo.
Covering is that.
What is the finding with regard to shifting the liability on the owner? Yes. It was a private vehicle.
It can be written on the ground. What she was the employee, you was employee of this court. What he has
So whether the vehicle is a white board vehicle or yellow board vehicle, private vehicle, not a transport vehicle. So what does the policy say for covers the inmates also? Policy. Not for hire and reward. That is under 147, 149.
Also, the student
All right. So thereby the tribunal is right in fastening on the owner. Yes. Hire and reward use ಮಾಡಿದ್ದೀರಾ ಅಂತ tribunal hold ಮಾಡಿದೆ. Correct? It is your own case also that you are traveling in this vehicle as an employee of the company, and the vehicle used is not a transport vehicle, it's a private vehicle. And then what is the amount awarded towards pain and suffering? 25,000. Huh? How many injuries have you suffered? What does the wound certificate say? How many fractures? And that is then 25,000 is correct. Next, medical expenses, what is given? Huh? What is awarded by the tribunal? That is what is the bills you have given? Have you given more than that? So medical bills is 8844. What is this 12,000 is for additional? So how many days you were inpatient? 12 days. ಎಲ್ಲೇ ಆಗಿರೋದು ಇದೆ ಆಕ್ಚುಲಿ ದಾವಣಗೆರೆ. So 8844 would be 8,900. You are inpatient for 10 days, 12 days. All right, 10,000 can be awarded. Yes, next. Loss of income during later period. Yes, ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಷ್ಟು? 10,000. That will change 6,500 into 3 months. 19,500. 19,500. Yes. That calculation will change. Loss of future income ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? That will change now. 6,500 ಆಗಿದೆ. 6,500 into 12 into what is the multiplier? 18. What's the percentage? 10. What's the percentage? 8 agide, you can take 10. 1,40,400. Loss of amenities is taken at? That can be taken at how much amenities just normally? 30, 40? 30,000. That's all. Work. Anything you want to say? Huh? ಏನಂತ? Higher and review. Higher and review. ನೀವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಅಲ್ಲ? Higher and reward pay and recover ಬರುತ್ತೆ ಅಂತ. Possessing of driving license will not become a fundamental breach. Full court judgment of this court. How case? There's one more case. The lowest case. I think fundamental breach is decided in that. What is fundamental breach? So whether this will become a fundamental breach, higher and reward. Then the entire liability will policy is there. So entire liability will have to be fastened on him, but pay and recover. Entire liability on him, you pay and recover. That is different matter. Unless the liability fully fastened on him, no liability on you if there is no policy. One is he is committed certain breach, entire liability on him, absolving you, but pay and recover. Like gratuitous passenger at Manura Khatun's case. If I am wrong, correct me, give me some judgment, I will change it before signing. Correct? Now you have to tell me whether it is a fundamental breach where you are not or to be ordered to pay and recover. So thereby, you please tell me, I'll give you chance till even tomorrow because I will not be signing the judgment. I'm just dictating main points. I will file reasons to follow will come in. So if there is anything, you can give it to the court officer. Work on it. Appeal is preferred by the claimant seeking enhancement of compensation. So vehement contention that the tribunal has committed an error in not awarding just and reasonable compensation. It is his main contention that the tribunal has taken the income on the lower side, which ought to have at least relegated itself to the notional income chart prescribed by the Legal Services Authority. And also on all other grounds, tribunal is awarded meager compensation which requires enhancement. He also contends that the tribunal has committed an error in taking the disability at 8%, whereas the Dr. PW2, who has treated the patient, has taken the assessed the disability at 30%. Eight. You're not challenged. Both of now, with regard to this doctor who has treated the patient, why it should not be taken more than 10%? No, how? What is the capability of the tribunal to make an assessment of medical examination of a witness, of the claimant? 1/3 is on the, if the doctor is not the treated doctor, he's at one of the, he's partially treated. All right, Berkeley. The income is taken by the tribunal is 3,500, which is on the lower side. The notional income chart prescribes 6,500 for the accident year 2011. Same is taken in this case. The claimant is aged 19 years. The appropriate multiplier would be 18. 18, huh? 18, as per the judgment of Apex Court in the case of Sarla Verma versus Delhi Transport Corporation. Stop. Claimant has got examined PW2, who was defined disability 30% to the left lower limb. But the tribunal has assessed the disability to be 8%, which is on the lower side. Even if 30% is divided into 3 parts of the body, it would be 10% to the whole body. Hence, disability is taken at 10%. We'll stop. In view of the same, the loss of earning capacity due to disability would be 6,500 into 12 into 18 into 10%. 1,40,400 as against 60,480 awarded by the tribunal. Stop. Towards pain and suffering, 25,000 is awarded, which is not disturbed. Towards medical expenses, tribunal has awarded 8,844, which is retained. Towards food, nourishment, and conveyance. Since the patient, the claimant was inpatient for 12 days, 10,000 is awarded under this head. Towards the loss of income during later period, in view of this court enhancing the income from 3,500 to 6,500 per month, and claimant having sustained fracture, 19,500 is awarded for a period of 3 months of recuperation, as against 10,000 awarded by the tribunal. Loss of amenities and enjoyment of life, 30,000 is awarded, as against 10,000 by the tribunal. claimant would be entitled total compensation of as against 1,17,480. Full stop. As per the table mentioned here in below. The tribunal has, you're also on the point of challenging liability to be shifted. Tribunal has exonerated the dismissed the claim petition against third respondent insurance company. Fastened the liability on respondents number 1 and 2, that is the driver and owner of the offending vehicle. Respondent number 2 was directed to deposit the compensation, which is questioned by the claimant herein in this appeal. Full stop. The fact remains that the insurance policy is in force as on date of occurrence of accident as per exhibit R2, which is not in dispute. The only ground for fastening and the liability as against the second respondent is for the reason that the vehicle which was involved in the accident was used by the respondent number 2, owner of the vehicle, for hire and reward. Stop. So there is a breach of terms and conditions of the policy. The insurance company cannot be absolved of its liability. The liability is fixed as against respondent number 2 and 3, owner of the offending vehicle, and the insurance company, as the policy is in force. Stop. However, the principle of pay and recovery will have to be put into force in this present case. Accordingly, I pass the following order. Appeal is partly allowed. Claimant is entitled to total compensation of cash as against 1,17,480. The entire liability is fastened on the respondent number 2 and 3, that is owner and insurer of the offending vehicle. Applying the principle of pay and recover, the third respondent insurance company shall pay the compensation and recover, or be at liberty to recover the same from the respondent number 2. The compensation shall be paid by the insurance company respondent number 3 on the date of petition till realization. Full stop. The terms and conditions with regard to interest and the deposit made by the tribunal stands intact. With regard to enhanced compensation, the insurance company shall pay the compensation interest at 6%, only for the enhanced compensation. The original records the record shall be transmitted to the jurisdictional tribunal forthwith. What is the total amount? 2 lakh. What is the point of this FD? And release the entire amount. Entire amount shall be released in favor of the claimant upon proper verification. Mr. Patil, you can submit any judgment if you want. I will also have a look at it because I have to see. Suresh Latur.
Yes, my lord. I am the appellant, claimants, respondents, my lord.
The insurance company appeal.
Yes, my lord. Yes, my lord.
Where is Pradeep B? There's no representation on behalf of appellant. Learned counsel for the respondent 1 to 3 is present. Release this matter next week. KL Srinivas. There's no representation on either side. Release next week. PG Yattal. Government. There's no representation on either side. Relist week after next. Yes. What is this? Is there a stay? But what is the order in challenge? What is the MA order? What is order MA order? That was challenged. That was withdrawn.
This is also quite the same in the matter. Oh,
He's not here. There's no representation on behalf of petitioner. Learned counsel for respondent is present. Relist week after next. Next. ಬೆಳಗ್ಗೆ ಇದ್ರಲ್ರಿ ನಿಮ್ ಸೀನಿಯರು ಬೆಳಗ್ಗೆ ಬಂದಿದ್ರಲ್ಲ. So he had an emergency, is left out of town. India. All right. At request of counsel for petitioner, relist next week. Mr. Gangi Reddy. No representation on either side. Relist week after next. Yes, Shankar Reddy. Any stays there?
After 10 years, in between, you know, that.
What is the order in challenge?
Rejection of the amendment.
Before the
Rejection of the.
rejection of amendment application before which court? In which proceedings? He has filed the original suit.
There was a simple original.
Settled.
But after 10 years, in between, that particular line where the rejection was done.
What happened to that compromise? Whether he has challenged that compromise? Or where the what is this maintainability of this? No, is it your submission after my putting forth? How's your petition maintainable? How's your petition maintainable? ನೀವು ಹೇಳೋದು ನಾನು ಕೇಳಿಸಲ್ಲ. Take the mic that is provided for people like you only. What is the stay, interim stay granted? In status quoendre. Correction. Who's in possession? Enjoy the possession. All right, we'll decide the matter next week. You enjoy the possession. You have not moved. Now you have come in the. Why did you allow status quo to be granted? You have not filed application vacating. I expect Shankar Reddy to do something more proactive than defending the case. Yes, no, counsel for the petitioner seeks time. Relist this matter next week. Uh, who was filed? Who was filed? Who are you? One and two? One and two? Gift deed. So defendant one and two have given an agreement of sale to plaintiff. That is earlier. After that, gift deed to you. Has he challenged the gift deed? Has he challenged the gift deed in the suit? That is question. That's rejected or allowed? Perfect allowed. You are Narsimurthy or Barbekala? Because now you are challenging what is allowed in his favor. So I'll have to hear him. What is wrong in allowing the amendment? He was aware. Yes. When is a suit filed? Huh? 2014. When is the amendment filed? Evidence is commenced. Yes, you are ready to. All right. Both learned counsel for the respondent number 1 seeks time. Relist next week. It does not matter. What is the stage in the suit? Next week we'll take it on Monday or Tuesday. Relist on 16th, 17th or 16th, 18th. Relist next week. Interim orders extended till next date of hearing. Where is the impugned order? So appointment of court commissioner. For what purpose? What happened to that application? Rejected. What is this you are referring to? Which document? Thumb impression. In which document? You want to refer for scientific investigation of which document? Registered order of investigation. So registered is there to refer it. Registered. There is some fraud played. Not read the file. But request of petitioner released week after next. Read the file, get hold of some judgments, come and submit. Don't stand here and turn pages. Shows bad on the lawyer. CST. Then appears for the parties released week after next. This is for that rural service. I think it is decided by a coordinate bench of this.
But in this particular case, there is no law at all. But
I think His Lordship Justice Dixit must have passed an order in. You are engaging Mr. Shashikant?
Yes.
Sailing together. Who's the answering respondent? Status not here. When do you want it, Mr. Shashikant? All right. Release this matter as request on 17th. On 17th. Huh? No, is there any urgency in this? Then you can mention on 17th, I will take it up at 2:30. Request of learned counsel for respondent released after 2 weeks. Yes. Yes, madam. Yes, what do you have to say?
They executed, they gave a bank guarantee of support. These all candidates.
state government, they have each allotted in the state government. State government, they took the admission, state government took all their job. Yes. When they took the admission, they executed the bond, and then they went to the college. Then the year side, I am finding the bond. They have challenged it, they get it from. They wanted to, yes, I think that two have to be. Because it is state government, state has allowed 2 years in college, they cannot execute any bond. It is only for the state they have, for which they have no issue at all, because they have already executed bond. Now they don't. Many schools are here, they have not. Because it is not a matter to be decided. The matters are still getting there. Therefore, we lost, even the necessity still for this. When the matter is going to why do we be here? You know, to oppose the report. Therefore, we lost, we all went through it at one day. And see the process. Go on to comment on that one.
So withdrew the suit. You withdrew. They are here.
They are here, they are fine here. They are.
All right. All right, I will decide the matter. Here, who's the government? Your ESC advocate. Where is the government is also here. All right. We'll have it week after next. All right. No, but others are served with the copy. Your request, madam, she will give you one more copy. I request learned counsel for the respondent 3 and 4 accepts the receipt of the WP copies of the writ petition. You received? All right. Release this matter on 18th. Request counsel for petitioner relist week after next. What interim order? Which course? Relist next week. Aital. 87. 87. AG, none appears for the parties. Relist week after next. Hello? 86 is adjourned in the morning itself. Oh. If that order passed, then you can say so in this case. Already it's adjourned. Serial number? $25. Wait notice. Interim order, if any, stands extended till is extended till next week. MVC case.
Court officer. Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಹೇಳಿ ಸರ್.
Serial number 66 ಕರ್ದಿಲ್ಲಲ್ಲ ಮೇಡಮ್ ಏನಾಯ್ತು?
66 ಅಂತ.
ಹಾ 66.
ಬೆಳಗ್ಗೆನೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್, ಹಾಗಾಗಿ ಅದು ಖಂಡಿತ
ಓಕೆ
ಒಂದು
ಮೇಡಮ್.
ಅಡ್ಜರ್ನ್ ಆಗ್ಬೇಕು.
ಓಕೆ ಮೇಡಮ್.
4 ಡೇಟ್ ಫೈಲ್ ಇದೆಯಪ್ಪ.